the other people.
No, so I am for the purchases. I have already given my affidavit. Your Lordship said I have already surrendered the document and also the possession. So I am only a third party.
Keval Krishna Mandirata.
Yes, Lords. Two directors.
In Arul's affidavit, paragraph 3, my lords,
Yes.
there's just one correction. It's 20th of June 2004, my lords, not January.
You want their paragraphs 3 also to be extracted?
Yes, my lord. Though they have that, it was similar to the earlier affidavit, para 3 can be done. They are only purchasers.
This appeal. There's only one order. Two appeals. Two appeals arise out of. The orders are the same.
Common order. Common order.
Arise out of the judgment and order dated 10/4/2025, passed by the division bench of the Kolkata High Court. In contempt case numbers. Contempt case number 57 of
2012.
GA number. What is GA?
GA, general application. In IA is called as GA.
So only the contempt case.
Yes, sir.
Contempt case number. Thereby, the High Court, the division bench, held the appellants guilty of willful disobedience, which are earlier orders. Where is the punishment part?
16, page 23.
For a moment, your lordship. One moment, your lordship.
You were in obvious contempt of the earlier
1
order.
minute, your lordship. Even
2012 onwards, you've been
one moment.
hanging on to the possession of the property.
No, it's open ground, your lordship. I have not even used it.
Whatever it is, you can't be absolved of the contempt. Though.
One moment, your lordship. One moment, your lordship. It's a family dispute, and one of the joint receivers has obtained a degree. That degree is in challenge before this honorable court, your lordship. This case has a checkered history, and there's an arbitration proceedings which are pending before this honorable court, which says that this property, he does not have rights over the property, your lordship.
We can't set aside the contempt.
As a check, your lordship.
What did you say?
Thereby, the division bench held the appellants guilty of willful disobedience to its earlier orders.
And sentenced them to civil imprisonment for 10 days, in addition to payment of fine of rupees 2,000 by each of them.
Rights of the party.
Agreed thereby. The present appeals were filed before this court, and by order dated, full stop, by order dated 12/4/2025, this court stayed the
No, your lordship.
ensued judgment.
Release them on bail. Didn't stay the proceedings. Only release the petitioners.
There is a stayed the impugned judgment and order dated 10/4/2025, only to the extent of the imprisonment of the appellants. They were directed to be released forthwith on bail on furnishing personal bonds. Fine has been paid.
Yes, your lordship.
We are informed that the fine amount, as directed by the High Court, has already been paid. During the pendency of these appeals, the appellants filed affidavits of unconditional apology, seeking to purge themselves of the contempt. We are now satisfied with the improved affidavits of apology filed by them, and take on record their undertakings therein as under Arun Madhusudan Putnani, the appellant in criminal appeal number 3800-3802 of 2025, while
November 2025.
But the earlier affidavit is where you tendered your unconditional
Yes,
apology.
Here,
That's dated 14th November 2025.
this one is dated 25/11.
This is 25.
The earlier
This
affidavit
one-
dated 24th November 2025.
You could have at least repeated that again instead of again saying, please read that earlier affidavit as
Sorry, Your Lordship.
an integral part of this affidavit.
I've stated so, Your Lordship.
Paragraph 2, my lords. Paragraph 2.
I've stated so, Your Lordship. Paragraph 2 I've
While
stated.
conveying his sincere remorse and submission to the majesty of this honorable court, filed further stated in his affidavit dated 25/11/2025 as follows, para 3. It is June instead of January of this correction of already. On the same lines, the appellants in criminal appeal number 3803 of 2025, namely Keval Krishnan Mahendiratha and Sachin Mahendiratha, filed separate affidavits of apology, unconditional apology, wherein para 3 is the same in both affidavits.
Yes, sir. Paragraph 3. And para 2 also. It's almost drafted together, I think.
Yes, stated as follows in their individual affidavits stated. What is the date of this one?
This one is dated, my lords,
No data.
14/11. Yes, ma'am.
14/11. Para 2 and 3. In the light of the aforestated affidavits and the unconditional apologies tendered by the appellants, we are of the opinion that they have purged themselves of the clear contempt committed by them and would therefore be entitled to reduction of the sentence imposed upon them by the High Court. The same shall accordingly stand reduced to the payment of fine alone without any sentence of imprisonment.
And period undergone, your lordship. They were inside
Oh,
for
they
2
were,
days.
they were inside. Without any further period of imprisonment, limiting it to the period of incarceration already undergone by them in civil prison. The appeals are allowed in the
Grateful.
Much obliged, Your Lordship. Please, Your Lordship, only one request. Any observations, not to prejudice me in the other country.
What observations?
I have got a civil appeal pending here, Lordship. This might should not happen.
What observations have we made on merits?
By High Court, Your
We have
Lordship.
not even said anything about your holding on to the property since 2012 onwards.
Because what has
Not said
happened,
anything.
much obliged. Sorry, Your Lordship, calling for troubling, Your Lordship.
Grateful.
Next.
Please, my lords. My lords, I'm for innocent Group D employees in West Bengal School Service Commission matters, my
Well, you
lords.
can't come up at this belated hour and say that we were unheard.
My lords, for the
There's no
past 3
question
years,
of
my lords,
reopening
my
the whole thing again.
if my lords may just allow me to make a submission, my lords, for the past 3 years, my lords, I've been shuttling between courtrooms and no courtroom has allowed me the due process under Article 311.
Did you,
My lord, just because
did you appear
I,
before the Calcutta High Court Division Bench?
my lords, I was there before the Calcutta High Court Division Bench,
Then
but my
if you
lords,
were heard, then you were
only-
heard. And you can't say that I wasn't heard the way I wanted to be heard.
Just under the guise of turning back the clock and treating me as candidates, my Article 311 rights were violated.
Sorry, we are not getting
No
going here.
charges have been framed. Just
The
one submission.
petitioners claim that they remained unheard throughout the process that culminated, throughout the judicial process that culminated in the judgment of this court in Baisakhi. However, we find no merit in this submission, and in the event the petitioners failed to advance the grievances during the lengthy hearings before the Calcutta High Court and thereafter before this court, it is too late in the day for them to now seek to reopen the issue. This petition is and is accordingly dismissed.
Discrepancy between the orders of the Honorable High Court and the Supreme Court. Just one small discrepancy, my lords.
Yes.
My lords, in the order of the Honorable Division Bench, the Division Bench states that only those individuals who have been appointed after the expiry of the panel or who have left blank OMR sheets must refund their salaries. However, my lords, the order of this Honorable Court, which is the final order, my lords, in that every tainted candidate is directed to refund the salaries with 12% interest. This is a slight discrepancy where
there's no discrepancy. We perhaps said that all tainted candidates will en bloc return the salaries paid to them.
My lords,
there's no question of you are trying to retain that ill-gotten money now.
My lords, if may just say P10,
we are not interfering, counsel.
Very well, my lords.
There ends the matter.
Item number 3. But a patta granted was sought to be overturned, my lord, by an order of the commissioner, which is completely without jurisdiction. Single judge finds so. The division bench disregards two.
You filed a writ petition against the district revenue officer's order, is it not?
In the first instance, my lord, when
and what was the order passed by the High Court at that stage?
High Court directed the commissioner to consider whether the suo motu.
Therefore, if the commissioner was asked to exercise power, you didn't challenge that order.
No, my lord, the commissioner's order.
No, the High Court order which directed the commissioner to exercise jurisdiction and passed
the direction
appropriate order.
Powers of revision.
Whatever it is the High Court which directed it. That order was never touched.
But assuming
it's too late in the day for you to now say that the commissioner had no jurisdiction.
Then I cast aside that argument. Assuming commissioner has jurisdiction, the two bases for the purpose of now setting aside the patta grant in my favor is that this land was
the patta which was granted to you after how many years of your delay?
No, by the same logic, in 2011, when I had gone to the High Court, had passed an order, which order became final, that was not challenged.
Which order?
The High Court order at page 36.
What is the date of
June
that order?
2011.
What is the date of the order?
30th June 2011.
It set aside and directed the ASO to consider it.
That's correct.
That's all.
Now ASO considers and grants me a patta in 2011.
That is set aside by the DRO, and then against the DRO's order, you
set aside by the DRO, in 2019.
Very well.
On a different complaint. There are two aspects. If my lords are troubled by the aspect of delay, this particular GO 714. This is now subject matter of two judgments of the Madras High Court. One which says that 714 applies only to appeals and revisions, not to an application seeking conferment of patta.
What is 714?
That is GO at page 30 of additional documents, which is the basis for the High Court to say that it is barred by limitation. 714 said, people are coming up with belated claims of appeals and revisions and asking for reconsideration of an earlier request that was rejected. So, 714 at page 30 of additional documents specified, that it would not be permitted. Now, this is the basis for the High Court to say that when my application is made for grant of patta, 714 would militate against my rights. Page 30, my lords may kindly have additional documents.
Yes.
P14.
Yes.
My lords will find from the third line, under the Tamil Nadu Estates Abolition and Conversion to Raitwari Act, so as to provide for admission of belated appeals or revisions on grounds of the petitioner having reasonable cause for not making appeals or revisions within the prescribed period. Now, page over, page 31. In the first para, last 5 lines.
Yes.
He has opined that there should be some finality to the settlement proceedings and that reopening of closed cases on one ground or the other by the authorities by virtue of the powers conferred on them.
What happened to this GO now?
So this GO remains. Now, this GO would be applicable for reopening of cases, appeals and revisions. But the Madras High Court has taken a view that this GO has no application when someone is making an original application for the first time asking for grant of patta. But because grant of patta, your lordships are aware, under the Estates Abolition Act, it's an existent right.
And how do you explain for the fact that you slept for how many decades? 7 decades, is it? 5 or 6 decades.
The petitioner before your lordships would note
49 years.
petition was filed in 2011. This was filed by my predecessors.
The declaration was in 1951, that is the Sarkar Vet Anadina.
But the authorities recognized that this land was treated as patta land, in the Faisal Patti of 1953. In 1961, for the first time when they carried out a revision, the land was not
Delay, Mr. Niranjan.
just one more minute. Important rights.
Absolutely.
Just one more minute. Just one minute.
Important rights because the land is now valuable.
No, just one contention.
Yes.
This Anadinam land, Leonard friend would also corroborate, is not something that is equivalent to government land. It is not Porambok land. Anadinam land means in a estate area which is abolished. If some person has not yet come forward for the purpose of making a claim, this I am told etymology comes from the Anadi, which is abandoned or orphaned land. Until someone comes and makes an application. This is not equivalent of it being government land. But the mistake division bench makes is...
The declaration is Sarkar Vet Anadina.
That's correct.
Not Sarkar is also there.
But Anadina, because it is Anadinam, at this point it vests in the government.
Therefore, at that time itself,
But in fact,
51 itself it vested in the government.
lordships would see,
Then
there is the office report which specifically says that Rajati judgment, which is one of the judgments that I am relying upon, is also pending before this honorable court. Two aspects of law. One is on the
on facts we are against you, so there's no question of giving you any legal points now.
Even on facts,
we are not going to allow this.
Last aspect of fact.
Some real estate baron must be behind you, and he's there in the background, and this must be, where is this land?
This is in some rural area. Now government wants to adopt it for industrial purposes, not residential or commercial.
Whatever.
One last fact.
Yes.
The 2011, when I first went before the authorities for the purpose of grant of patta and I went before the High Court, they were heard. High Court directed that my application for grant of patta must be considered and granted in 2011. So delay may not operate against me. In fact, the revision of reopening today is happening after 10 years. Patta granted in 2011, several transfers take place. I am transferring for bona fide consideration for good value. Now today, my lord, in 2018-19, the DRO wants to reopen. High Court asked the commissioner to consider. So, my lord, I am actually a victim of the delay at the respondent's hands.
After you woke up after 5 decades.
But I am the purchaser.
We find no good ground and reason to interfere with interim judgment passed by the head, especially sections according to dismissed.
Item number 55.
Yes.
55. But the trial court holds in my favor. But the High Court, what it does is, but it upholds the trial court order so far as the counterclaim is concerned, but allows the subsequent pleadings to the written statement without taking into consideration
Returnable loan. You want to stay of the suit?
Please.
16th February.
I'm so very.
Meanwhile, there shall be stay of further proceedings in
civil suit number.
Suit number 1527 of 2020 on the file
of 2020
on the file
of the City Civil Court, Calcutta.
City Civil Court.
I'm so very grateful.
Just look at the details, man. City Civil Court, there must be a judge or something.
It's the 10th bench. I'll just apply it. This is the 10th bench. 10th.
Which page will be fine?
I'm sorry, Matt?
Which page will be fine?
This is on page 44. This is the application under Arbitration.
Page 47. Okay. That's how they describe it, is it? 10th?
Yes. Well, there are 13 benches, including the Chief Judge in the City Civil Court.
10th bench.
I'm so very grateful.
Malad, generate petition for the expedite hearing, Malad. Just for a minute.
We are not here
Malad, only
to arrange the board of the High Court.
Malad, just kindly for a minute only, Malad. Malad, this.
Whatever issue you have to address the Chief Justice of the High Court. We are not here to
Malad, just kindly.
micromanage the
Malad,
High
just
Court.
kindly, for a minute only, Malad. Just kindly consider my thing. Malad, in 1995.
You are 80 years old, we know that.
Malad's petitioner is 80 years. Malad, but the question is, Malad, the 1995 award was in 2008 award was passed. Malad, in 2035 for technical petition, Malad, and the same is pending before the Honorable High Court, Malad. Despite the fact that the SLP has been dismissed by this Honorable Court in 2017, Malad. Malad, I am only requesting that kindly just for only 4 weeks or 6 weeks, whatever.
You've not even updated the status report.
Malad, I filed
What have you filed at page 197?
Yes, Malad, this is status
It's
report.
only of 4th November 2024.
No, Malad, just kindly.
1 year old.
No, Malad, no, I'm sorry, Malad. Just kindly see the top of the page, Malad, 197. Date of filing is 8 October 2013. Registration date is 8/10/2013.
What is the date of this document though?
Malad,
This document ends with 5/8/2024. We don't know what happened after.
Malad, Malad, this is a case status, Malad. So this is a case status. I have just.
Look at page 199. The last
Malad.
entry is 5/8/2024.
Malad,
So after that, the case has not come out.
No, yes, Malad, it was not listed after that, Malad. I have filed an.
Either way, you have to address.
Malad,
the
Malad, just kindly consider, Malad, I'm only requesting.
What direction do you
Malad,
think?
I'm only requesting you dispose of this as soon as possible on 4 weeks, 6 weeks, Malad, whatever, 2 months, Malad. I'm only
Approach
requesting,
the Chief
Malad,
Justice,
because of,
please.
Malad, just kindly consider that, Malad, because of that issue, Malad, the financial condition of the petitioner is very.
We find no grounds to entertain this petition filed under Article 32 of the Constitution, complaining of delay on the part of the High Court in disposing of an execution case. However, the writ petition is accordingly dismissed. It shall be open to the petitioner to approach the Chief Justice of the High Court to seek expeditious disposal of the execution petition filed on 8/10/2013.
Yes, Malad.
Filed on 8/10/2013,
EC number 470.
which is still pending as on date, wait for whatever it is.
Malad, the same may be expected.
You
Malad,
approach
only
the
one request, Malad.
We won't do anything further, Council.
Malad,
No more.
I'm grateful, Malad.
This is as much as you'll get.
Item 19 was mentioned.
19.
Should it be?
Just call it, let us say.
I'm retail.
19.
Wait,
Yes.
this matter comes up pursuant to a Lordship's order of 28th October, Manoj, requesting Manoj the file to be placed.
Yes.
Here, the file is with us. Manoj.
One moment.
If the Lordships
One moment.
recall, Manoj.
Let's have, consideration. '34 was dismissed on 2nd February 2019.
Yes, Manoj.
Then you filed a regular appeal.
Yes, Manoj. Which the court,
That was on
that appeal was filed.
27th August
27th August
2019. So that was itself delayed.
That was delayed, Manoj.
Not that, 27, of course, we,
Yes, Manoj.
Bose brothers, perhaps that will
Yes.
come to your aid to some
The
extent.
appeal was
High Court,
Then after that, let him complete thereafter.
but the High Court dismissed the appeal, saying that Manoj, it should have been.
You need
filed
to
as
file a commercial
appeal. So, Manoj, that was dismissed on 20th
20th September 23,
And Manoj, 7th October 23, we filed a commercial appeal.
17th October,
17th October. Lord.
17th October.
Yes.
So
And the
you
court-
have. All right. So
Court proceeds, my lords, with the registry objection from the date of judgment of section 34, saying 944 days delay. Then the court, my lords, also says that COVID. period. So this was filed before COVID, my lords. COVID has no application to this case.
very good.
Then the High Court says, my lords, that there is a delay of, according to the High Court, my lords, 173 days, which it's actually 143 days delay. But be that as it may, my lords, the High Court dismissed it, my lords, only on the ground of delay. All I am saying, my lords, is your lordships may restore the appeal, my
Why
lords,
do you say it's 143 and not 173?
that if we count the days, my lords, from the original period of the 34.
No, so now we will take which period into account? From 2/2/2019
Yes, my lords.
to 27/8/2019.
Yes, my lord.
That's the date of your first filing.
Yes, my lord.
So that's about,
One,
206
March.
days.
you've counted?
206.
no, no.
We have
206.
prepared a chart.
You take it that it's 206 days.
145 days according to us.
Did you apply for a certified copy?
No,
Is there any deduction to be
we're
made?
not asking for that.
So 26 days in February, then
31 minutes in March,
31 March, 30
30 in
April,
31,
31 May,
then 26 in,
June 30.
yes,
You went in August only.
yes,
June 30, July 31, and August 26.
26.
30,
145.
16, 90, 120, 150, 176, 177, 178, 179,
Yes.
6,
60 days.
It's 206 plus 2 plus 70.
205 days maybe.
Plus 27 further.
Then 205 plus after this 20th September, then you filed on 17th October.
Yes. That takes it to
The 60 days will have to be 60 days.
60 days is
From the 205 minutes.
Very.
So 145
145
plus 26.
plus here you have 26 days.
1 second.
So rightly calculated 173.
26.
26.
So it's 5, 11, 6. About 171, 173 days, roughly. So let us see that AG's opinion. In your condolence, you said that the
Yes,
matter was
the file
referred-
was sent, yeah, we took the opinion of the Advocate General.
Where is the condolence application?
The condonation of delay application, your lordships will find minutes at
Page 169.
IA 7016 of 2024 at 169.
Yeah. You in fact asked for 944 days
From the
from the initial.
Yes,
But you didn't ask for exclusion also.
but this was the condonation. I didn't ask for exclusion of that 60 days.
No,
No, you
the
can-
time taken by you before the regular court, before you filed before the
No,
commercial court.
no, that we have not. But this will be, it will
No,
apply.
para 18. Para 18.
You mentioned section 14 though.
Yes.
Para 18 they have.
Right.
It will start, if lordships come to page 173 minutes. Stated and submitted upon receipt of information, opinion was sought for in the matter, and the office of the Advocate General gave opinion on 10/6/19 for filing an arbitration appeal. Submitted upon receipt of the opinion, statement of facts along with.
When did you ask for the opinion though?
That was on 29th May. 20. If the lordships have the file minutes.
Till 29th May, you didn't even ask for the opinion.
The first opinion came from the advocate who was handling the case on behalf of.
Have you flagged the relevant pages? Have you flagged the relevant pages?
Yes, they are flagged minutes.
They are flagged?
Yeah, they are flagged.
Green color.
Yes. But there is a separate.
This one letter dated 28/3/2019.
Yes, but before that minutes, 20th February 2019.
February.
20th February, yes, minutes.
That's not been flagged? Or there is?
The beginning minutes.
Right.
This is the.
No, the 28th March is before the 20th February. It's in reverse, is it?
Sorry, minutes.
The file runs in reverse?
Yes.
Yes.
There are the notice run in the
Yes.
upper direction. So papers, correspondences run in reverse.
Well, in fact, there's a date chart which my friend has made.
This 20th February.
20th February 2019 is the opinion of this advocate Chandra Sekhar Prasad Sinha, who appeared in the 34 matter minutes, and he gave an opinion that this be.
On 20th February itself, he gave
Yes,
the
ma'am.
opinion.
Yes, ma'am.
2nd February is the dismissal.
Is the dismissal.
And he gives it on 20th February.
Yes.
happened after
The
20th
file
February?
moved from the executive engineer to the chief engineer's office, 28/3/19. Page 2, running page. Notice in Hindi, I'm sorry, it has not been translated.
28
Yes, madam.
अतः श्री चंद्रशेखर प्रसाद सिन्हा एडवोकेट्स एंड अधिवक्ता द्वारा प्राप्त कराए
वैदिक परामर्श की
प्रति
refers to his opinion, madam.
करते हुए अनुरोध है कि इस संबंध में उचित दिशा निर्देश देने के
Goes madam to the chief engineer who on 20th April 19.
So they take steps once in a month, is it? Once in a month, one step will be taken.
At least some step was taken.
Well, why does it take a month?
I understand.
for the process?
I understand. That's
Yeah,
the
these kind of processes need to be streamlined when you're dealing with matters which are
commercial,
in a timeline.
Absolutely right.
But that doesn't happen. Even IBC matters, we have the government coming here and saying, no, we are entitled.
That is the
to
problem
that."
everywhere.
Then change the law then. If you want to say that limitation should not apply to the government at
I'm
all,
not saying that.
say that, then we'll test it.
Lordship is right. Some guidelines should be given to the department as well.
Look at your dates also, once in a month, and then you skip July altogether.
No, madam, then 29/5, if a lordship come to running page 20, the note sheet, madam,
That's not been flagged here.
in the beginning.
In the beginning,
No, this part.
is it flagged? Oh, 29.
At the top, the lordship will find 20 within bracket.
20.
Yes,
20.
madam. This is where, madam, the law, this is 29/5, madam, the law officer of the state panel.
No, this is 25 is what has been flagged. 25 plus 10.6.
Yes. I'm sorry, but that should be 29/5, madam.
So it should be 29.
Yes.
No, but
Page
it's
20, if the lordship says, madam.
page 20.
Yes, yeah. This one, madam. The lordship says that, madam.
Handwritten.
Yes.
Yes.
Not handwritten, madam. Signed. Over the page.
Over the page. Yes.
तदनुसार प्रसंगित मामला माननीय उच्च न्यायालय में अपील दायर करने के से संबंधित है, वो तो विषय में महत्व एवं गंभीरता को देखते हुए विधिक परामर्श हेतु संचिव विद्वान महाधिवक्ता को स्थापित किया है. This is when.
So there is no covering letter also.
No, based on this, madam, the matter goes to the next page. You'll also will see, madam.
That's his AG's opinion.
Yeah, on the file itself. Madam.
On the file itself.
Yes, just have that AG's opinion, madam.
You don't address a letter to the AG to
The file itself went to
the file itself goes to him.
And he's noting the lordship will see on the next page, 21. Advocate General at the top of the lordship.
No, there's no delay on his part though.
He did it, madam, immediately. Yeah, and he also mentioned that page 20 to put up the page.
We were
keeping in view the timeline.
Maybe the delay was on the part of the AG's office, but
No,
he
it's
seems
not.
to have been very prompt.
Yes, ma'am.
29th May you send
And
it,
in fact,
10th June he gives it the
he
opinion.
flags it saying that this is a time-bound matter, please file it at the lordships have the penultimate third peruse the letters. Opinion and award placed at C so and so. I'm of the view opinion dated so and so placed given by conducting lawyer. MD CSP Sinha. Advocate is perfectly in order. State Department of Appeal
Without any delay.
delay, taking into consideration limitation.
In spite of that, how many months did you take after that?
After that, madam, the appeal was
You
filed.
don't file it till August.
27th August.
So you took 2.5 months, more or less.
Around this.
2.5. After he says that you should not take time. So what do we do? How do we oil these wheels so that they move a little faster? Borse Brothers also says that the explanation needs to be cogent, isn't it? With this kind of the mills of God and of the government
goes back to the
very,
department.
very slowly. At some point of time, you have to divorce yourself from the mills of God and start moving a little faster. That's not happening.
In fact, Advocate General says you file immediately.
He says that in spite of that, you take 2.5 months. Why should we keep on dragging this matter? This award is of which year?
2005.
2005.
May I say this, madam?
And reasonable,
What is
partly allowed, partly rejected.
Your lordships may impose some cost on the state, madam.
How
And
much is the financial implication?
the award, madam, is of
45 lakhs.
No. 77.62 lakhs plus interest.
No,
Below is
only
43 lakhs principal.
with interest it was 45, at the
At
time
that
of
time.
award, at the time of award.
Now it will be much more with the
Much more
interest
with-
component.
Also.
The losses may impose some cost, my lord, then let the court decide, my lord. In any case, I have lost in 2 courts, let me have my day.
But why should we take a lenient view of this kind of delay on your part, which on the face of it is unexplained? Why do you take 2.5 months after the highest law officer in the state tells you need to do it immediately? Then why should we come to the rescue of a state which just drags its feet?
Maybe
No other
some,
word for it.
maybe some compensatory cost, my lord, will send a message also.
If I may submit it.
Losses may impose some cost, my lord, let the court.
It's only 45 lakhs.
43 and all.
43.
Only 1 second.
The operating portion will
If it also-
straight away.
If a lordship sir page 82, 83 minutes.
Third column. Permission by letter framework if I can point out. At page 84, with serial number 8,
Yes.
third column, Lord, interest is payable on the amount of award of item number so and so. He has allowed
Item number
principal amount only with respect to 3 items.
Yes.
So item number so and so amounting to 43 at 6% per annum. That is, he delivered the award within a reasonable time. So page 85 top, we'll find the total amount. And then page 85 middle will find it is 45 lakhs and odd.
Yes.
6%.
Other, if it is not paid within time, as stipulated by the learned arbitrator, then interest will be paid at 10% per annum on 43 lakhs. Therefore, 43 is the principal which he has taken. And what has been tested at least before a court of law, once.
How much is it coming to now? It's only 4 lakhs per year.
Yes.
So it's
It is party
compounded.
is also.
no, it's
It is not
70
compounded.
no, it's, my note says 77.62 lakhs. Minutes.
Now,
It's not,
Yes.
it's
Ah.
not, it's not
No, it will be more, my
it's
lord.
not compounded. Interest is not
It will only
compounded.
be
10% after 31/3/2006.
Mr. Chaudhary, I don't know.
4 lakhs.
Well, yes, the losses may impose cost, my lord. Let the message also go,
Yes.
my lord.
No, we'll send out the message in this,
And-
that you need to
And my lords, in fact,
pull up your
So you won't
socks.
get the fruits, that also sends a back.
in the High Court, my lords, I think one hearing will be.
Having examined the original file placed before us, we find that the learned Advocate General of the state of Jharkhand offered his opinion in response to a requisition dated 29/5/2019, almost immediately thereafter, on 10/6/2019. He specifically stated therein that an appeal should be filed before the High Court without any delay, taking into consideration the limitation period involved in the filing of such appeals. Despite this observation by the highest law officer of the state, the appeal was not filed till almost 2.5 months thereafter, that is on 27/8/2019. In these circumstances, we find no error having been committed by the High Court in rejecting the appeal filed by the state of Jharkhand under section 37 of the Arbitration and Conciliation Act 1996 on the ground of delay. It is for the state to take measures to see that the process moves faster in relation to cases which need to be filed within a time-bound manner in the light of the statutory limitations prescribed therefore. Limitation prescribed therefore. The specially petition is according to its needs.
Extremely grateful.
It's
We'll see from later.
Please, item number 2 and password information which argue council is sport man 50 minutes.
Item number 4.
Please.
This legal notice and condoned delay petition have been filed.
My lord, I am just he has requested to because his matter is
Very good.
please.
Pass.
Clear.
Five.
may I please, Minutes.
could not put a table for you. Item 5.
Yes.
Yes. What happened to the writ petition?
Writ petition, nothing will happen.
Nothing.
It may take it,
Nothing
nothing will
will
happen.
Yes, yesterday you have filed the counter in the matter of the bench on record or
There.
here you have filed.
Therefore, two requests, a longish counter running into 76 pages were filed only yesterday, I think.
You need time.
Yes, this although
This one number.
respondent
8 to 16.
8 to 16 and
I think it's been placed.
it is placed on record.
It is placed.
Two requests I have. I'll file a rejoinder, permit me. Also, Milos office report indicates that though one of the original writ petitioners were earlier Milos represented, but now the learned advocate has given a letter saying I don't represent him.
Which respondent?
Respondent number 7, Milos.
7.
Yes, I can't help it, Milos, if the person is not engaging an advocate.
No, but 7 is deleted already.
No, Milos, 17 to 19 was deleted.
No. Have you got the office report dated
Yes.
112?
Yes, Milos.
It says respondent numbers 7 to 17 have been deleted from the array of parties. We have only one case or two?
Yes, only one must be.
It's only one.
17 to 19 Milos must have been deleted because our application for deletion was for 17 to 19, but I have to serve 7 Milos. Office report indicates. Milos Lordship.
The Kaustubh Prakash.
Sorry, where is
He
it?
filed affidavit of service on R7.
Yes, Milos. Yes.
There's something wrong with the deletion part of it. 17 to 19 have been deleted is what they said in the paragraph.
Yes, Milos.
17 to 19
Have been deleted. 8 to 16 have filed counter. Lordship second paragraph.
Yes.
It is further submitted that on so and so as he filed rejoinder to counter of R1 to 7. That was the original writ petition. We filed rejoinder.
Right.
It is submitted that advocate so and so for R to 6 has sent an email stating that he has filed counter for R1 to 6, though inadvertently it has been mentioned as R1 to 7 in the index and also in the first para. Kindly treat the counter affidavit as R1 to R6. Thereafter, Mr. Kaustubh Prakash petitioner has sent a letter through email stating that rejoinder by the petitioner may be considered as a rejoinder to counter of R1 to R6.
But why do you have to serve notice on
Because
R7?
that's why I don't know why office report says service is not complete on R7 at the penultimate paragraph because we have filed an affidavit of service.
Where do they say that?
Milos,
Oh, I see. Service is not complete.
yes, Milos, service is
Having recorded that.
we have served.
There could be any number of mistakes in this.
Yes, Milos, sometimes in the late at night, Milos is prepared. I don't blame having being AOR for 25 years. It's difficult, Milos, for the registry. But Milos, Lordship may.
Very well. We find that the office report dated 1/12/2025 is defective, in as much as it records, on the one hand, that the learned counsel for the petitioner E5, an affidavit of service on respondent number 7, stating that the said respondent was served through speed post.
Yes, Milos.
And a copy of the speed post received was also annexed with the affidavit. Full stop. Having said so, the office report ends by stating that service is not complete on respondent number 7. Further, we find from the tabulated statement therein that the office report reflects that respondent numbers 7 to 17 have been deleted from the array of parties, whereas the earlier paragraph states to the contrary that respondent numbers 17 to 19 have been deleted from the array of parties. The registry shall take care while preparing the office reports to ensure that such mistakes do not occur.
Lordship's tabulated chart says 17 to 19 only.
No, our chart says 7 to 17.
Oh, all right. Maybe mine is 17 to 19.
How is it then? There might be a difference between.
It must have been uploaded later in the night. They must have realized the mistake. That's all right. Lordship,
Ours says 7 to 17.
It must be some error, but this happens.
7 to 17. My brothers also says 7.
Very well. Two requests.
Very well, doesn't matter. You don't take a print of it.
Two requests I have.
Yes.
The
Learned Counsel, the counter affidavit filed by respondent numbers 8 to 16 is taken on record. Learned Counsel for the petitioner is permitted to file his rejoinder thereto within 2 weeks.
3 weeks. Within the vacations are coming, I'll file it before
Within
then.
3 weeks. What is the second request?
Because Lordships had put it for disposal today with an observation that let it be retained the position in the list because my plans are sanctioned. You know.
Well,
But since the counter has come only 2 days back, you know, if I don't rebut it,
list on
Consider one aspect, yes,
20th January, matter shall retain its position.
Can you consider one aspect in a letting file as counter, but otherwise actually it is against an interim order.
No doubt, but the High Court has to be more mindful about IBC matters. They seem to think that 226 permits them to surface is one aspect. Now, IBC also. Karnataka High Court unfortunately has been the forerunner in this exercise. And Orissa seems to be now following. Which court now? Orissa High Court is also following suit now.
I'm very grateful. Anything else?
Grateful. It will come up in January.
Yes, 2020.
Should I kindly recall this matter was heard at length on the last occasion. Inadvertent error, my lord, mismatch of GST because of which my receiver is not able to
directed
pay.
us to file one affidavit. So that
Not
is,
filed?
no, it is filed. It's not on record, but it's been filed yesterday.
Nice.
But I'm carrying copies with me.
Have you served it on the other?
Yes, sir.
Yes, sir.
We would like to go through these affidavits before the hearing. This is not. Then why do you file them at the last
No, we should have done
possible
it.
minute? Not you. Everyone does it here.
We actually
We give time frames. Those time frames are just for the larks.
Signatory.
No one abides by that.
This case, the signatory had some issues, my lord. So he couldn't sign it last week. It's the only difficulty. We got it ready much before.
But why can't you at least streamline the process like you have done it with income tax?
Should have done.
Income tax, this tax deducted at source. As soon as you enter the PAN, I think you now in the form 26AS or whatever it is, automatically it all comes. So that should also be done with this. You can't pick upon SSCs and say that you made a mistake, we won't give you the benefit.
No, so this affidavit that we have filed.
And now who is the victim? Not even the petitioner. It is that other company which will not get the ITC. Is that fair though?
No, but my lord, our affidavit will indicate perhaps the quantum of filings and the number of.
Maybe so, but why don't you try to improve your systems so that everything is streamlined, everything is in, what should I say?
Looking forward, my lord, we should be doing.
It should be in sync with whatever is happening. If they file the GST, I mean, if he's corrected the invoice, the point of sale, is it not? He corrected the point of sale.
GST number.
No, GST number he did not correct.
Yes.
Point of sale he corrected, but he didn't correct the GST number. Now you say that because of that, that FedEx company cannot get the benefit.
No, he can get the benefit provided they come within the timelines. That's our only case. And everybody who's corrected, lakhs and lakhs of people have corrected.
But that doesn't mean that you should not improve your system and you should put the blame on them and try to.
This affidavit will also indicate, Manoj, how robust our system has been working. So they will indicate, Manoj, we haven't any other.
This is the third or fourth case now.
This is third case.
Third or fourth case.
Yes.
So obviously there are glitches.
Absolutely not. No glitches because.
No, that's because these people, they make mistakes and then you don't allow them to rectify them.
Then be rectified within 8
It is.
They can't.
And what is the loss that is cost to you?
Well, it's purely cascading effect.
What cascading?
Maloj may have it with this affidavit.
You need to be more business friendly. On one hand, you profess to be, and then you pick on businesses like this and say, though you paid, I won't give you the input tax credit.
18 long months they have, Maloj.
But if they're entitled to it, why can't you just extend it to them?
Maloj may see the law and Maloj the affidavit, have it any other day.
We are informed that the affidavit was filed in terms of the earlier order only yesterday. However, the same is not on record.
This side of the vacation.
And put up the same.
This side of the vacation.
Do you need to file anything in response to that? Based on this side of the vacation is difficult. You've got just 2 more weeks left to go. 28th January.
Better to retain his position.
It's given you a Wednesday so that there's a better chance of your matter being taken.
It's a very short interval.
28th, Wednesday, you'll have a better chance.
Retain
Retain its position would apply if it's a Tuesday. For a Wednesday, it will come, the Wednesday's list is shorter.
Any Tuesday because today it was
Tuesday again, right? You don't expect the matter to reach on a Wednesday.
No, I do, but
Wednesday we'll also have more time to hear because I'm sure he will come, so he will have plenty to say against you. So, in anticipation of his lengthy arguments, it's better that we give you a Wednesday.
If I may request top of the board on this.
No, if you come up on.
Number 7.
7-11 matter.
Yes.
But 7, I may need a password, and read them ready. I'm so sorry, Milord.
I have a small plea. When this matter came, your lordship issued notice and granted a stay of the interim judgment. The stay of an interim judgment when 7-11 is dismissed.
Stay of the interim judgment?
Yes. So the problem now is they are alienating the properties which are subject matter to suit, and they could well argue later.
Unfortunately,
saying
that this is there in the bench.
It's my unpleasant task to say that the effect of the stay, my lords,
If my friends could permit a password.
and Mr. Srinivasan, I'm sure, able to respond to this small matter only on the question of
It can't be a
stay
small
of the
matter when Mr. Gopal is appearing.
because now they're alienating the properties, I think, under cover of the stay.
All I'm asking
I
for
will place an agreement on record.
All I'm saying, pass it over. We'll do it today.
Very
Also,
Item number 8.
We'll find out very fast.
Well, I am pleading for the respondent in this case.
settled?
No, it is not settled.
Not settled.
We could not
You
settle.
were told that there is a possibility of settling.
Yeah, we did try, my lords.
Not happening.
Certain things had take their own time.
Yes.
The issue, my lords, is a short one, that mandate of the arbitrator has to be extended and a substitute arbitrator has to be appointed. And a substitute arbitrator has to be appointed, my lords. If my lords would recall, I had mentioned the arbitrator is charging more administrative charges than his fee. In fact, the administrative charges exceeds the fee to a certain extent, and in the other matter is more than 2 lakh rupees. Despite the High Court saying you give the details of the administrator, he refuses to do it, still continues to charge. And my lords, at the end of the day, it is very embarrassing for one of the parties to come up before the court and say this is what has happened. Now there is a bias against me in case he has to continue. No, my lord, that was the short question, and if your lordship should recall, your lordship said, is he not charging clerkage over and above the fee? Because he is an advocate, so basically, my lord, that is the short point, my lord. We can have another arbitrator. Nonetheless, my lords, 4 applications have been friends client. Time and again accusing the arbitrator of bias. Certain issues which he has said in 4 applications before the High Court, before filing the application before the High Court, which led to the passing of the order by the High Court, saying give details of the administrative. Despite that, he does not. That is the question, my lords, we can.
Are you at least on the same page with
My lord, I submit. Kindly see para 8. Court has dealt with it.
You don't want the
extensively.
arbitrator to be substituted.
And he has been asked to.
He does not want the.
My lords, let me show as to whether, my lords, what he says before the arbitrator and before my lords would just see. Kindly see para 8, page 4 of the judgment. Court has dealt with it, and there is no provision to substitute. We have already paid lakhs of rupees fee to him. He is to conclude the proceedings. They are not reading the evidence. The evidence was closed, these were reopened. They are amending the claim time and again. Now they themselves, I said, they themselves made an application for terminating the proceedings.
Firstly, I made an application that time is over, we should seek extension. Then, which they opposed, and arbitrator said no, time is still left. Then they made an application next day rather reading the evidence.
Yes.
Well, also let me just show what he said before the arbitrator repeatedly. And what kind of allegations he levels
When
against
the
the
only
arbitrator.
provision available is when he zeroed the
Wait for your turn.
My lord should kindly see the arbitrator is
Please
appointed.
wait for your turn.
My lord, the arbitrator is appointed, and at page 42,
Yes. Yes.
the fee is fixed, my lord. That is, the appointment is, in terms of the order, the fee of arbitrator is regulated by fourth schedule, and in interim measure, it is directed that the initial a sum of rupees 1 lakh each in arbitration so and so, and a sum of rupees 1 lakh each on arbitration so and so. They shall be paid by claimant as well as the respondent. Now, my lord, this is the first order of the High Court is at page 37, fixing the fee as per Schedule 4. And this is the first order if the arbitrator passes.
What did he say in his affidavit against the arbitrator?
With this,
No, you said that he has said something against.
yeah, arbitrator is going to show one by one.
That?
My lord, I'll show. The first one he says is in the rejoinder, my lords, page number 21 of 19 of the rejoinder.
The rejoinder.
Rejoinder, my lords, I have put it at one page.
Page 19.
Page 19 of the rejoinder.
Yes.
This is the application. The first application that he files is 15/6/2021. And
Thank you.
at page 21.
Is partnership deed.
My lords, I am on the rejoinder.
Yes.
My friend, I am on the rejoinder, not up.
21.
21 of the para 7.
Sir.
Much to the deepest regrets, after first procedural order dated so and so, this arbitral tribunal has been constantly affording uncalled for, unjustifiable, unwarranted opportunities to the claimant, so much so indulgence to the claimant to file statement of claim without there being any justification. Secondly, without there being any provision to do so in terms of the procedural order. Over the page, my lords. Para 10. That it is submitted, Honorable Tribunal has already shown much indulgence to the claimant in respect of collection of evidence for finalizing statement of claim of the claimant, and the claimant has illegally, unauthorizedly taken away the records of the respondent, firm from the office of the firm, for which the respondent had to dial 100 and call the police for help in regard thereto. But my lord,
he's basically saying that the arbitrator is favoring you.
I'm just trying to show thereafter what he says more. More in the second application. More applications he files one after the other. Now, page 28 is the second application which he files.
Yes.
And my prayer in the first application is, please, prayer in the first application, my lord, says page 27, the arbitrator.
Well, he wants termination of the arbitration.
Terminate. He himself wants termination. Now, just I'll show 4 times he does this, my lord. Second application, my lord. 15/6/2021 is another application.
Yes, wants to ask. Let's come to the relevant portion.
No, I'm just reading the prayer part. The much has to be said otherwise. Page 48. Even otherwise, this Honorable Tribunal may be graciously be pleased to terminate the arbitral proceeding. So he himself had been saying this all throughout. Now, third application. Third application is page 52, page 69. Page 69. Terminate the arbitral proceedings. Now, after having said all this, and the allegations are even more grave, very grave allegations he is leveling against the arbitrator all throughout. Now he said, since you have gone to the court, you are saying about administrative charges, I will run up and say to the arbitrator, look here, the bias should be against me. And my 29A6 is pouched in a very broad language. It says the court, while extending the time, may substitute. Now, these are good enough reasons for substitution. But be that. No. By page 76 before the High Court, he seeks termination and refund of the fee.
This is his application.
His application.
76.
76. Refund the fee and please, I'm not taking my lord through the end. What he says all throughout. Prayer.
Krishna Kumar Fatehpuria. Krishna Kumar Fatehpuria is the respondent.
Respondent. Thereafter be directed to refund page 76, terminate and refund. Now, all throughout he has been saying this. Now, the point that begs consideration of your lordship is what to do in circumstances like this, my lords. In circumstances like the present one, where we tell the arbitrator, because he's taking administrative fee in every hearing, virtually 25,000, 40,000. And just see the synopsis, my lords, I've tried to put it across. My lords, at page G, at page E, sorry.
Page E.
Page E. My lord, just sees the foot of the page A6. Now the administrative charges is at page F. My lord, the charges is 3rd of June, 25,000 incidental cost. 21st October, 25,000 incidental cost and expenses. 9th January, incidental cost and expenses. 15th June, administrative.
Each of you pays 25,000.
After the order of the High Court.
50,000 each time.
First go, 50,000 each. Second go, my lords, on 21st October, again 50,000. Third, 50,000. Fourth, 30,000. Fifth, 30,000. And after the order of the High Court, again he does it. Now, where does a person who is before in the arbitration, when does he raise his voice? Either he keeps quiet and keeps on paying, or he comes to the court and says, what is this?
Could his fees have been under the fourth schedule?
My lord, under the both the
fourth schedule, it would have come to 6,10,000.
Yes. No, it would have.
That's what you said in para A.
3 lakh. What?
Para A5, you said that.
My lord, I guess.
Arbitrator fee as per schedule 4.
3 lakh 5,000 to be paid by both the parties. By each party.
So 6,10,000.
2 lakh has already paid.
So you've already paid 4 lakhs.
4 lakh. In the other matter, my lord, I have paid more fee and more administrative charges.
You can't now direct refund of the fees.
No, I am not asking for it. At the end of the day, I want someone to adjudicate it impartially.
You asked for the appointment of this arbitrator.
No, I never asked, my lord. The High Court on its own did it.
High Court on its own.
On its own did it. We said any arbitrator and the High Court. In the other case, my lord, my learned friend says 1,64,000 in the fee per party and we have paid 3 lakh in excess.
When was he appointed?
My lord, see, 2020. That is 13th of March 2020. During COVID, I am told.
You mentioned it in the list of dates.
My lord, so it is there. I just said 13th March 2020.
13th.
And
March.
That is.
Yes, Mr. Singer.
My lord, my humble submission is what my friend is raising the grievance now. I raised initially.
Now you've changed your mind.
I filed the petition. It was dismissed. And when is it para 4?
You have now changed your mind. You want to go with the same arbitrator.
Same arbitrator. We have paid lakhs of rupees to pay the fee. And now we are not going to pay fee to the new arbitrator. And my friend who is now opposing it never asked for any account from the arbitrator.
If you look at the
direction by the court,
payments,
directed that you can see
the payments were all made before your request for termination of proceedings.
Absolutely.
My request
was
that
you made the payments after that for you to now say that I have paid so much, therefore I don't want termination. You had already made those payments by the time you did ask for termination repeatedly.
No, it's my that not termination is on account of limitation, my lord.
Whatever it is, you asked for termination of the arbitration proceedings.
Not otherwise.
You also
And
made a request for
earlier
refund
my
of the
petition was
arbitration fees.
because their counsel who was appearing was a friend of the arbitrator, which was not accepted by the court. And regarding these charges, This was court has given the entire finding that charges are according to Schedule 4. And we should ask for the account. Never account has been asked by him or me. And they are changing their claim. Initial claim for was 8 crore. Then it was a 2 crore 46 lakhs. Again they changed it to 2 crore 56 lakhs. So, as per schedule of fee is still.
Will consider.
Court has already said in para 4 of the judgment.
Para 4
of the judgment.
Yes.
It was, however, clarified that all expenses required to be paid will be on the basis of actuals, and it would be open to petitioners therein to ask the arbitrator to account for administrative expenses charged by him. It was also directed that arbitrator cannot enhance the arbitral fee in the guise of charging administrative expenses. Either party challenged this order. Then 26 para 8. Insofar as the contention of London Council for the petition that London arbitrator be substituted, as he is consistently demanding administrative expenses in the guise of the fees concerned. In the earlier round of litigation, the court-wide order dated 28 January 2022 negated the contention. It was held that the court was unable to accept that charging of any administrative expenses renders the arbitrator D0 or de facto ineligible to act as an arbitrator. Court had, however, clearly directed the arbitrator not to enhance the arbitral fee in the guise of charging administrative expenses. It was also made clear that administrative expenses will be charged on actuals and it will be open.
Is the arbitration going on endlessly like this?
My lords, because firstly, because of the COVID.
We have the expert report has come, objections have come, their evidence has come.
He appointed an expert.
Expert was appointed, my lord. They restarted the evidence. And they have to be cross-examined.
And took the money to his own account. So the arbitrator said, I'll appoint an expert. While the expert...
No, not the expert. No. Not the
Single, please don't interrupt while he's speaking.
My lord.
You want to say something?
By the time that the expert was given the report and was being cross-examined, the arbitration proceedings stood lapsed. And then I moved an application. I said, no, it can continue. Arbitrator said it can continue. My learned friend said, no, it cannot continue. Time has lapsed. So in order to see that tomorrow there may not be an objection under 34, I said, okay, let us go to the High Court. And while I went to the High Court, and we raised this issue earlier also before the arbitrator, in the first court, please give the accounts of the administrative charges, which he refused to do. Now, just in 29A6, so that is my last argument. It is not that the power is not there. High Court somehow says my power is not there to substitute an arbitrator while extending the time. Let me just read.
Where does the High Court say?
29A6.
No. Where does the High Court say it has no power?
When I was arguing, that is what was said.
What it was.
It is not recorded. But anyway, just read 29A6.
What is there?
29A6 power is very wide. I put it at high. That at the time of extending, the court may substitute one or all. Yes. So this is one reason where it could.
Yes, Mr. Singhal, you wanted to say something more?
My lord, kindly see, I have read the para 8, whole grievances regarding administrative expenses. Court has asked that he cannot charge and you seek account from the arbitrator. What is wrong in it? No, we are at very advanced stage.
Application under 29A,
5 years
extension of time which he
My lord, it is at page 123.
123 of the SLP.
Of the SLP.
And he opposed it by filing a reply.
Reply.
That's also filed?
That is also.
That's another.
The application that I filed,
Yes.
which starts at
Extend
page,
the tenure.
yeah,
And where is his reply to that?
his reply is at page 134. And my rejoinder is also there.
But this seems to be speaking substituted arbitrator.
Yeah, more the like a substituted arbitrator.
But in your application, you asked for extension of time.
Extension of time as well as
And also appoint.
as well as substituted. Or prayer B.
So there he says, don't appoint a substitute.
Yeah. After having said whatever he had to say, this one.
This is dated 24/5/24. Very good.
I'm grateful. I'm blessed.
Judgment. Yes.
Appeal for list.
Yes, Mr.
My intra-court appeal, that has been dismissed solely on the ground of delay without getting into going to the merits. Whereas the learned single judge, by relying upon another judgment without going to the merits, has held that the entire scheme is lapsed.
Sorry?
The learned single judge, by relying upon another judgment which is on facts which is apparently different, has held that the scheme has lapsed.
I see.
Under the Development Authority
What
Act.
happened to that?
Authority Act.
You challenge that order?
The other act is
What happened to that other order?
It's a distinguishable. It's totally on different facts here. Because here
Which part of the same scheme?
Scheme
acquisition is under the same.
Must be same scheme. Must be same scheme.
Then won't that have an impact on this?
No, the property. One second, sir. One second, sir.
Not only that, there are
Property
of orders which are confirmed up to this honorable court.
Property is different.
Is that same scheme which I also had occasion to deal with?
Yes, there are series.
There was one
That order is passed in the facts and circumstances.
Karnataka scheme.
Yes.
Lordship has said that in the facts and circumstances, yes, it was dismissed. One was against that.
May not be the same.
Para 4.
Acquisition is different.
This 27.
In relation to the order
Which has been relied upon in the impugned order. Para 4.
this 11/12/2019.
Correct. With 27/9/23 order.
No, 11/12/2019 is the
I
order.
have seen that. No, let me see.
I have not got a copy.
Irrespective of that, let me point out to 2, 3. This one, which is apparent on the face of it. Yes.
This
Now, kindly turn to.
This SLP was also filed by the Bangalore Development Authority.
Yes.
But you're not aware of it, Mr.
I have not. Because
Just
in
go
fact, yes, in fact, I have produced all those orders with other companion matters where my lord the
This possession was not
But
taken.
this judgment is referred to in the single judgment.
But the factual distinction is possession is given. I am the intervener. The dispensing pump has been allotted to us. I foresee and the subsequent dealer.
Now, kindly have a, one second. I'll kindly have a look at the single judge order. That's at page number 58.
58.
In the present case.
Yes.
It was a 2019 writ petition, and at the same year immediately it was disposed of and asked when it was listed. Kindly turn to page number 61. That's all is the finding. Learned in page number 60 bottom,
yes,
he refers to another case Learned counsel for the petition submitted the scheduled property measuring so and so, so and so, so and so is the subject matter of the present petition. In support of this contention, he relied upon the petition of Puchama so and so, which I will point out later.
This is another judge.
Yeah, another judge.
2000.
Yes. Then learned counsel for the response have not disputed the decision in the case so and so identical to the present petition so and so is concerned. Even the factual aspect of the matter is evident that survey number and other records, except to the extent that petitioners are stated to be the owners of so and so in survey number is the same. In all the facts and circumstances, these petitions stand allowed in terms of the order dated so and so, that is Chama's case.
You are represented before the learned single judge.
Yes. This what it shows that it was represented by an advocate. That's all it shows. Immediately it was listed. Some R2 and R3 was represented by number 59.
Mr. Indiresh.
Yes.
Indiresh was for R1.
For R1 and Rajaram Suryam by
Suryam.
That's what.
Is for R2.
Yes. Now kindly take the relied upon judgment at page number 40.
No, but in the body of the order, there is no mention of anyone taking notice.
Nothing is there. Say 2007.
Did this council appear for you or no? This Suryam Bail.
Find out exactly.
Rajaram.
But it is never their case that they were not represented. I have seen your entire petition.
Now kindly go to page number 440.
No, let me try to understand this order.
This is the order passed. Relied upon the previous judgment. Now kindly go to the previous judgment.
Well, let me see what the prayers were, because what you read out is neither here nor there.
So, in fact, look, that Puchama is the same judgment which is confirmed by your lordships, which was shown to your lordships.
No, that's a 2019 order.
No, that is appeal. Look, against that,
2017, 2019 order.
Because what has happened actually after Uchamma is, Uchamma and all those orders were passed under the previous regime, where under the Pune Municipal Corporation, your lordships had
that judgment was holding.
Yes, now because in these cases, the compensation, I am appearing for the state. The compensation was tendered in the account, in the court, by the acquiring authority, and Panchanama possession was also taken. So these cases were lapsed because under Pune, the lordships had taken a view that actual possession and actual tendering has to happen. After that, the law is
development.
And therefore, under the Indore development, 5 judges, the lordships have held that even if it is the compensation is tendered with the the registry of the bank, then that would also be good compensation tendered, and Panchanama possession is also good possession. So both the things have taken place. So that those judgments are under the previous regime. And after that, what your lordships have done in DDA versus Tejpal have condoned DDA even for 10-10.
Wait, I am arguing my case.
He is supporting you though.
I'm let some patience. Now kindly go to page number 40. Relied upon case.
40. Is Uchamma.
Yes. It starts from 40. The relevant para would be para 6 at page number 43. That is in the Uchamma's case. Para 6, having heard the learned counsel for the parties, I find that admittedly award has been passed as back as on the year 1994. So far as compensation has neither been paid and landowner's petition not deposited before the civil court, not deposited. As rightly contained by the learned counsel for the petition, there is no legally acceptable material on record to show that possession of the land has been taken. On the other hand, so and so. This is the factual finding in Uchamma's case. The compensation was not either deposited nor possession was taken. Now, in the present case, possession has been taken. There is a document which you have produced, and the compensation has been deposited, which you have filed along with the rejoinder. Now, kindly take our counter. Yes, Mazar at page number 36, which is an admitted document. Even in the writ petition pleadings also, they say that there is a Mazar taking possession. However, they say that it is not a genuine or it's not sufficient. Page number 36.
Who says that this is not genuine?
No, he says that it is not sufficient.
Who?
The petitioner, the respondent.
No, but that aspect is not touched upon.
Not touched upon. This is the mother taking possession, and the deposit, the compensation, the deposit of compensation in the instant case at page number 39, P5.
this amount doesn't tally with what they say is the award amount.
Oh. How do you explain that?
If there is a difference, that's a later aspect. This is in respect of that, they don't deny also about this amount is not relatable to this one. Yeah, the only case is that it does not tally, that's all.
If the award mentions what the compensation is payable to this person.
7,20,000. And what they show is something different.
6 lakhs.
They can't relate this check to any particular award, etc.
We have categorically said that we have deposited the amount in our affidavit and these documents you have produced and possession has been taken, admitted.
The amount must be relatable at least on the face of it.
It's 35.
And if you make the deposit, you must also have filed a document saying that this is deposited to the credit of so and so case number. Some proof should be there.
We are not produced here.
Just a check is shown to us now.
But you have said that categorically this amount has been.
But the amounts are also not telling. So at least if there is a case number, then that way we can put
They would
two
not
and two
tally
together.
for the reason, because the cumulative compensation
I'm
for
sorry,
various
but
beneficiaries are deposited.
State government has nothing to do. It is for the BDA to explain. BDA comes out with this case, Milord. I'm sorry, Milord.
Let us
Yes,
have
fine,
some clarity
sir.
on what exactly.
Yes, fine.
We don't have a document to show that this amount was
Not produced, but we said in affidavit, on affidavit you have said that this is the amount which you have deposited before the concerned court. That is our category.
How much land did you acquire altogether?
It's about 36 guntas.
37 is this person's part.
Yes, yes. 26 guntas here.
The total extent is only 36.
Yes, 26 guntas, and that has now been allotted to 3 entities.
No. Scheduled property is 37 guntas.
26.
Now, your notification is dated
26 guntas.
26 guntas.
88.
Total is the 397 acres.
397 acres you acquired.
397.
397.
Total altogether. It's a scheme longer, this one, and entire vast area is developed. Now it is allotted one to Indian Oil Corporation, other one is to.
Even if we say that you are in possession, their entitlement would be to the higher compensation under the 2014 Act. Not that they will get back the possession of the land. But that issue also we need to have some clarity as to what exactly you did.
Yes.
To bring it within this ambit of indoor development also, we'll need something more than what you're just offering us. But according to you, the amount was deposited in 2001.
Yes, 2000.
2001.
Correct.
Till 2019, they did nothing.
Yes. Waited for about 18 years, then he filed a writ petition, saying that his scheme has lapsed and.
Where does the scheme lapsing come in?
Because it is no development.
Not the acquisition proceedings lapsed. There's a scheme which has lapsed under your development act. That perhaps some other issue had come up before me. With regard to that. Scheme called?
Scheme, no specific scheme, but later they developed it as a layout, like different layout, Mishra layout.
BTM stage 4 layout.
Stage 4 later. 4 layout. Stage 4 layout.
BTM 4 stage layout.
4th stage, residential layout.
Residential layout.
Recall.
And in the writ petition pleadings also at page number 50, kindly turn to page number 50. While filing a writ petition after 18 years.
What do they say in that?
They say in after about 15 lines after Annexure E, after passing of the award, in page number 50 in
after passing of the award?
Yeah, after passing of the award, a stereotyped merger dated 5/11/93 is prepared by the Bangalore Development Authority, a copy of the merger. They acknowledge they are aware of it.
So they claim that they are in actual possession.
Yes, but still they say that they are in possession.
What are these photographs that they filed? At that time, it was an open land, is it?
These are vacant lands at that time.
No. Now there's a petrol pump.
Now they are allotted to 3 entities.
Not the dealers, not. In fact, they filed 3 suits against us and the IOCL. All suits have been dismissed. Now they have filed a fresh writ petition about that.
After the dismissal of the suits, this
They filed
petition
3
is
suits.
filed.
Yes, my lord. I have made a list of dates for 3 suits they filed against us, the dealers and the IOC also, my lord. I am the person who has been allotted the petrol pump and I have been established.
Where is your list of dates?
Yes, lord.
Lord, before that,
Come back to you,
I
Mr.
know.
Mabray, there's no need for anxiety.
No, there is only one thing. She claims through IOC. IOC itself has stated in its application that what is allotted to them and what is the suit property are distinct. Lord, they can't come out with a case that same property. There may be confusion, whatever, but the specific case of the IOC.
Why would you sue them then?
That's what
If they're on a different piece of land, why did you sue them?
That was under wrong advice. That's a different thing. But
You're saying that you're not claiming that land.
Therefore, please see the application.
What is your stand now? You're not claiming the land that is in the.
I'm claiming the land which is described in the writ petition. But please see IOC application.
You're not answering the question.
That I would have to seek exact clarification about that. But since IOC itself comes with a specific case that it's a distinct land.
No, we can't keep on going back and forth now. All of you take your seat, Mr. Nabil.
Please.
Let Mr. Natraj complete thereafter.
Yes. Single judge has not gone into any of the aspects. He straight away simply followed the other case, which was on facts are totally different. The division meet just dismissed it solely on the ground of delay of 150 days. So just before the COVID time.
COVID time?
Just before that, I think. So some
21.
150 days, just 120 days.
21 was still COVID time.
Yes.
157 days.
Yes, just 157 days below us.
It's very interesting. Perhaps this 157 days delay is not much. Considering the nature of the order which was under appeal, there's absolutely
there are two reasons. Please have a look at this.
At least there was something for them to say before the appellate court. Unsuited on 157 days delays.
Keep aside that.
We are only on that.
No. For that,
we'll send it back to the High Court now.
Lord, please see page 61.
Delay ought to have been condoned. You can address all issues there.
Lord, I will come. Just have a look at page 61.
61.
Lord, all these arguments are not open to them in view of, and they don't say that this is a wrong statement. They should have applied for review in that case. Page 61, para 3.
To begin with, we have no clarity whether the BDA was even represented. Because in the cost title, the name of a council is mentioned, but the learned judge specifically records that state council accepts notice for R1. There's no mention of someone appearing for R2.
But Lord, it is neither their case in the appeal nor before the Supreme Court that nobody appeared on their behalf, or it is without any.
The order seems to have been passed on the first day. That's admitted.
Because
it accepts notice and then the disposal.
Page 61.
So it obviously the order was passed on the very first day itself.
I go on the basis of what is recorded in the order, and if they dispute that, they have to proper remedies to state so on oath and move the single judge.
Let the appellate court examine all issues, Mr. Mehta. To be consulted on this ground is perhaps not a proper.
Lord, there is one more thing. Lord, there are 5 more judgments of the same nature which has confirmed up to your Lordship's court. Lord, I have brought them before your Lordship.
Cite them before the High Court then. Cite them before the DB.
They did the review order, no? But the allotments were made subsequent to the same.
They are not going.
They granted. Appellant,
bank. The Lordship may only keep all questions open. So
all issues are left. We are not even going to say anything. Who is the second appellant? I see.
Lordship may permit us to participate in the proceedings there because they have not.
You won't say anything. You need to file your applications there once the writ appeal is resolved.
So we had filed application. Your Lordship
an application there, not before. Not very well. We'll say that you are at liberty to.
Very good.
You filed an intervention.
Yes, no.
Which has been ordered.
No.
Not yet order.
Because it never got listed thereafter.
We have also filed.
The appellants,
IOCL and the allotment.
the Bangalore Development Authority and its additional land acquisition officer, are aggrieved by the dismissal of the writ appeal, being writ appeal number 601 of 2020, within brackets LA-BA, on the ground of the default of 157 days. The said appeal was instituted by them against the order dated 18/9/2019, passed by a learned judge of the High Court of Karnataka at Bengaluru in petition numbers P5143-P5147 of 2019. It's LA-BD. Perusal of the order passed by the learned judge reflects that he followed an earlier decision of the High Court in Srimati Uchamma versus State of Karnataka and others, within brackets WP number 21831 of 2016, decided on 15/9/2017. Quite close. There is no clarity emerging from the said order as to whether the appellants were actually heard on that day. It is clear that the reflections were disposed of on the very first day, as notice was accepted by the learned State Council appearing for respondent number 1 wherein only on that day, and thereafter the learned judge proceeded to dispose of the matters in the light of the judgment cited supra. Agreed by the said judgment, the appellants approached the division bench by way of the writ appeal, but with a delay of 157 days in its filing. By the impugned judgment dated 19/1/2021, the division bench opined that sufficient grounds were not made out for condonation of the said delay. Why does the division bench say that the delay is not just 157 days but
Because
much
actually,
more?
going by the dates, my lord, it was filed after 1 year and 2 months, going by the dates. So, my lord, there some
I see.
More delay, what they mentioned here.
But the COVID period was not deducted.
that was not shown, that was not even claimed by them.
The order of this court was already.
I know, but my lord, somebody has to claim that so that.
But the High Court was not aware of the COVID order.
It was before the.
That was cited across the country, Mr. Navrin. I was aware of it in Manipur. Karnataka was not aware of it.
Therefore, I'm not saying that delay was of not 500 days. Not exact delay was not, perhaps was not.
It appears that the division bench was not apprised of the fact that this court had already directed exclusion of time owing to the prevailing COVID pandemic.
It's not clear.
At that point of time. Therefore, the conclusion drawn by the division bench that the delay was not just 157 days but much more, and that it remained unexplained, is therefore not correct. On that ground, we are inclined to hold that the delay after exclusion of the period covered by the COVID pandemic in terms of the orders passed by this court would be within condonable limits and ought to have been condoned so as to allow the appellants to have their say on merits. The appeal is accordingly enough. Setting aside the impugned judgment dated 19/1/2021 passed by the High Court, dismissing writ appeal number 601 of 2020, even that bench 28 on the ground of civil the said writ appeal shall stand restored to the file and shall be dealt with on its merits and in accordance with law. Applications, the interveners who filed applications before this court seeking to be brought on record on the ground that they have an interest in the matter are at liberty to file their intervention applications in the writ appeal before the High Court. We make it clear that all issues have been left open to be addressed on merits by the division bench after hearing all sides, all parties concerned. Considering the period of time that has elapsed since the filing of the writ appeal, we would request the High Court to give priority to this matter and decide the same as expeditiously.
Any date to be fixed for us to go and appear there?
No.
Otherwise, we will flag us for some
They won't
expeditious disposal, we are unable to start our.
We, in aid of this, we direct the parties to it. We direct the Registry of the High Court to list the matter for the appropriate bench on when is the vacation there?
January 4th reopens, 5th reopens.
5th it reopens. They won't have a.
They have the vacation
Sankranti
came like now.
From 20th.
They don't have a Sankranti vacation.
Sankranti no, that's in Andhra.
That's only in Andhra and Telangana. All right.
Maybe only a
So,
solar.
5th it reopens, is it?
5th reopens.
Very good. List on 6th January. And the party shall appear before the High Court on that, on the said day. It would be for the High Court to thereafter list the matter for hearing on an appropriate date as per its convenience.
Deeply obliged.
May I just request for physical applause?
Sure.
Grateful.
Manoj, one request, Manoj, the respondents, Manoj, they may not interfere, Manoj, in running my petrol pump, Manoj. They may interfere.
We've not said anything on that.
But their foods have been discussed.
Once the writ appeal is restored, whatever you wish
Very
to
well.
say, you'll have to say then.
Item number 10.
Yes.
My lord, this is a case where the trial court has convicted the accused for a death penalty for rarest of rare case, the rape and the death, my lord. And the High Court
acquits him.
High Court acquits, my lord. So, for the perusal of your lordship, I have just made a short reflex.
And documents which are in your natural usual order. The copies of the record shall be furnished to the learned translator and for the parties. List on 3rd February.
Obligations. Much obliged.
Yes.
The railways has filed an application for implement.
Oh, you filed an implement?
Yes, because the entire prosecution was carried out by the railways under the Railways Act.
They were not a party in High Court matter.
You're not a party there.
No. What happens is the inspector would my lord see the past titles in the trial court. It's through the inspector. Now the inspector was represented through the railways panel, and that's how it is usually there. Here the state has filed.
Let them come.
The state has filed, but it will be the railways who will have to contest.
You need to file a reply or something again?
No, Mullahs, not the reply, Mullahs. Just that because the prosecution, this is against a conviction. Lordships will have to examine that. The prosecution witnesses and others.
You don't need an adjournment again.
No, we don't need
Nothing can go on today.
Please, Mullahs, but the witness statements are not here.
Witness statements are not.
We have filed.
We've granted you exemption.
Mullahs, I'm told that, I'm sorry, Mullahs, I'm told that a reply is also filed by us.
No, replies. You don't have a reply. No reply is filed.
No reply is filed.
There is no reply.
There's an implement application, Mullahs, may follow
Your
the
implement
act as-
application is here,
Yes, Mullahs.
but we don't have any reply filed.
Yes,
Yes?
yes, that's what. The court may consider the application.
Do you need, does anyone need to file a counter? The state also?
No, madam, no.
No,
Not necessary. So you can go ahead with the matter.
Yes, madam.
But witness statements are not there.
Witness statements are not there.
You've not filed the witness statements.
My lord, I have not filed it. Whereas it is there in our judgment.
They extracted. Witness
Yes.
statements are extracted in totality, then
Not totality, just the relevant portions. Would my lords kindly see that at annexure P1, I may just indicate page 21 is where the PW1.
Because you are saying that there are discrepancies in the prosecution case.
Yes, my lord.
Would you be able to work to demonstrate that without the witness statements?
My lord,
There's also a confession statement which was recorded in this. So he is also
Confession
doubting.
with recovery?
Yes, Minister.
What recovery? The railway property.
Railway properties, yes.
They recovered pursuant to his confession.
So whether there was a recovery, then a confession statement has been recorded in this. There's also
after the recovery, a confession statement won't.
Yes. There's also one.
If you already found the property, it's not pursuant to his confession.
Yes,
So there's no 27 evidence.
So there was also another accused, Fulchen, whose confession statement was prior in time. That confession statement actually led to the present accused. So that all
won't help you.
Very
well. Beyond the co-accused naming him, you don't find anything from him. You don't find anything with him.
No, the entire recovery, he was the owner of the property. The recovery was carried out at his place. At his place, the entire recovery has happened with two independent witnesses.
At his place, pursuant to the other man's confession.
Indicating that there is also material. He is also an co-accused. He was also involved in similar offences. On his statement that he is also involved in such similar offences. Therefore, we negate that place. Yes. And there is no explanation coming forward from him to show as to the ownership of the property.
So at the most, you might say that he is in possession of stolen property.
That's right.
How do you attribute the act of stealing this property itself to him?
So even possession under the Act, under possession of stolen property
itself. For Section 3 conviction, that is
sufficient. Yes, would my lords kindly see Section 3?
The property itself is of railway or not, it was not clear at all by the statement of PW's.
But
whereas
PW's, if you require that evidence, then it's better that we have the statements then. You'll be able to file the full statements?
Yes, we will endeavor to do this.
You? Whichever one of you wants to file the statements of the witnesses?
We'll do it.
IA number, sorry, criminal MP number 297571 of 2025. By way of this application filed for imprisonment, the officer wants to come, not the railways. The East Central Railway.
Yes.
Dhanbad, Jharkhand, represented by its Divisional Security Commissioner.
Yes.
Is that the
affidavit is by Senior Divisional Security Commissioner.
Divisional Security Commissioner.
Because RPSB pleaded as a party in this. Yeah.
Railway Protection Force. Railway Protection Force or East Central?
This is the Railway Protection
Protection Force, East Central Railway, Dhanbad, Jharkhand, represented by its Divisional Security Commissioner. Seeks to come on record. The application is accordingly ordered.
Would my lords otherwise requisition the entire record?
Amended memo of party shall be filed by the newly completed respondent by the next date of hearing. Registry is directed to requisition the trial court record in this case, as the statements of the witnesses would be of relevance.
Because the office report also indicates there is some counter which was filed on the 26th of November on our behalf, but probably it's not there on the record. We'll also ensure that it's there by then.
No, I just saw the office report, it says no counter. Why is that? There's another office report.
Well, the objection is probably because once that improvement application.
It's 1st December only. It says counter not filed. This is another. For counter affidavit marked as defective.
Last.
Yes.
Probably
on
because
behalf
the
of
order of
complainants and pleader. So it's defective, you need to.
Yes, we'll take necessary steps. Absolutely.
List on 10th February. Exemption from surrendering granted earlier shall stand extended to the next day.
Obliged.
Please, Lords, as per the office report dated 25th of November, the Respondent number 2 and 3 were answered.
Still answered.
Please, Lords, we have furnished the fresh particulars on 29th of November. So, Lords may have it after a week. Item 12.
There are two matters, is it?
Please, Lords.
Is in 12.1, Your Lordships, I am representing respondent number 2 to 5. I have already filed my counter.
As per the office report dated 24/11/2025, respondent numbers 2 and 3 in SLP criminal number 8422 of 2025 still remain unsolved. Steps shall be, you already.
Yes, Lords, we have already.
Steps shall be taken to complete service of notice upon them by the next date of hearing. List on 17th February.
Item number 13.
Your Lordship, 12.1 is 12.1 also.
Both will have to vote. Once they are tagged, they will be taken up.
Obligation.
In 13, my service is incomplete. 2 people has been died, so that's why my service is incomplete. We have
Has
to
been died is wrong. It's not a past continuous. You die and you're gone.
Yes,
there's no past continuous.
I apologize, my lord.
This will continue there.
Do
not prolong their death. They will go at one go.
Right, my lord. There are 2 matters because we have to bring legal heirs in 2 matters, my lord. There is 13.7 and 13.37, my lord.
13.7
and 13.337.
The office report dated 31. This is 31/7/24. Is there a later office report?
Well, if I may clarify on that part first. Well, I am placing a list of cases wherein the respondent had died. I have placed applications towards
17? No. I was going by this one. So there's some office reports. Okay. Maybe this one is 17.
Well, as per this list, we have filed applications wherein we have stated date of death of the respondent, the deceased respondent. The state has not taken any cognizance of that matter, has not completed the LRs. So as of now, I'll give, as far as these petitions are considered,
let them be placed before the registrar's court to complete all.
Because they are abated, they stand abated.
You have to file applications to set aside abatement. Office report dated 17/11/2025 reflects the details of service and demonstrates that service is incomplete in some of these matters. Further, we are informed that the respondents in 13 matters in this batch have expired and steps have not been taken.
Those IAs have been placed on record also. So we filed the IAs for bringing on the record that the deceased respondents have been dead, and their LR's information has also been provided by way of the IAs which are on record.
You filed IAs?
Get filed.
Just inform them or to come on record?
Please come on record by way of advance service, they were informed. May kindly see the IA number which I have placed as well.
Don't mention that. What did I say after?
But the VIA was not responsible in 13 in this batch.
Don't say that. You are informed. Further, some of the respondents in this batch of matters have expired and appropriate steps need to be taken. Matters may therefore be listed before the registrar's court for completion of this process and may be listed before this court after the same. You go before the registrar's court, complete all this and then come back.
Right.
13.
Item 14, I am appealing for the petitioner. In item 14.1, I am responding number 7. I filed a counter yesterday only, so
You're also
14.1, I am the petitioner.
You've received a copy of
We
the
received
counter?
just this morning, brother.
You need time
We need some time to file it.
Learned Council appearing for respond number 1 in SLPC number 84P of 2024 states that the counter affidavit.
Respondent number 7.
7 in my
Respond number 7 states that a counter affidavit was filed yesterday. However, we do not find the same on record. Registry is directed to verify and put up the same by the next date of hearing. Learned Counsel for the petitioner is permitted to file his rejoinder date in the
2 weeks.
List on 20th January.
Yes.
Number 15.
Yes.
I am appealing for National Highway Authority of India. I am appealing on behalf of state.
Yes.
This is the recovery against the compensation on land acquisition, your lordship. Earlier, the government has granted us.
So what have you said?
Lordship, in the counter, I have annexed one table which clearly shows that the whole case of the petitioner is that the land has been acquired and the compensation which have been released by the NHI, and NHI is now recovering much more than what has been released. This is not the case. This is completely false because there are 2 khasra numbers which have been acquired.
But have you given them any notice?
Yes, it says Lordship. There have been notice also. I just pass on. I have prepared a 2-page note for the
Where's the notice? It's in fact a notice to which
T12, T30, T14. All these are notices, show cause notices, given them an opportunity to reply also, but in the petition itself only.
Page number?
Page 87, 89, and 91.
87.
In fact, Your Lordship, they have tried to place on record the.
No, it's a demand, Mr.
Yes, sir.
There is
Required from you that you pay. This is not putting them on no cause.
Your Lordship, it is hereby directed from you to pay the dues.
Asking them to pay.
You straight away, you have quantified the amount and you are asking them to pay.
Next time, or explain the reason by appearing why the oppressive action be not initiated against you under the Revenue Code Act.
To explain why the oppressive action should not be initiated.
In fact, they have.
There is show cause notice asking them to explain as to why this amount should not be recovered. That is not there.
Lordship, one second.
You in fact threaten them with oppressive action.
No,
explain as to why oppressive action should not be taken against you. If you don't pay.
Lordship, what they are trying to do, there are 2, 1 second, Lordship.
They are not even put on notice that excess amount has been paid to you. This is how we have calculated it. What do you have to say about it? You don't even say that to them. Straight away you say this is the amount that we have paid in excess. Pay it, otherwise face oppressive action, or explain as to why oppressive action should not be taken.
Your Lordship, may kindly come to page number 5 of my counter for a second.
Counter.
But these are not the notices, right?
Your Lordship, and just bear with me. Please come to page number 5 of the counter. There is a table.
No, you give them an opportunity and
Your Lordship, they themselves, they have not placed on record one document which is Annexure D, which I have annexed with my IA number. Just look at that, Your Lordship.
Give them an opportunity. Give them the details of how you have quantified this excess compensation. Then you take a decision.
Your Lordship, there are 2 khasra numbers. Your Lordship, may kindly just see the table because it is sacrosanct, it is clear. There is no, it is not the case where NHA is asking for something more than what they have paid.
You don't decide it unilaterally is what we are saying. You made the payment.
Yes.
Now you say I paid you excess.
First of all, I have not made the payment.
Whoever
I have
has
not
made the
It
payment,
is the state of the.
you would have given it to the state makes the payment, and now you say that excess amount has been paid, but you decided unilaterally.
What is
They are not asked to participate in
They
that.
are not the only landowners in these khasra.
Whoever it
They
is,
are the
if you want
they
to
themselves are saying.
recover excess compensation, you can't do it unilaterally.
Page 64 is
Your
a
Lordship,
notice,
kind-
way of notice, your Lordship may
Page?
64, the notice issued by them. Itself speaks the truth. No date, no inspection, nothing.
Overpayment of amount.
Please. Mails.
According to the report, the compensation has been received irregularly by you.
Has been done to
Therefore, you are directed that you have to confirm depositing the compensation amount by appearing in the office, otherwise recovery certificate would be issued like land revenue.
Page number 64.
Done to you, that's a dash.
This is the LAO who is now acting at your behest.
And the Hindi version is next 66, the original notice. Nothing has been mentioned. Only the stereotype notice you have to pay.
This can't be. You can't do it unilaterally.
Your Lordship, you are hereby informed that according to the report of the land record keeper in the land khasra number 444D acquired under the Delhi Meerut Expressway by the National Highway Authority of India, payment of rupees 1,18,09,980 has been done to you on so and so date of the land khasra number 444D measuring area 293.
So you are now disputing their land holding. It is for them to explain to you how that land holding.
Mr. Lordship, what I am trying to say, they are owner of 1/9.
We are on not on the merits. Did you ask them to explain before you decided? That is all that we are concerned with. If you pass an order which has adverse civil consequences, the party affected thereby is entitled to be heard. Simple principle natural justice. Principle of natural justice. There's no question of getting over it. Very well. We've heard you. You've obviously not given them that opportunity. And that's why you're trying to go on to the merits of it.
Lordship,
Leave granted.
Lordship,
Leave
appearing on behalf of the state, only prayer is this at this.
Did you give them an opportunity?
Not actually notice was given,
Notice to pay.
That everything
Notice to pay after you take a decision is not what is required.
What I am submitting.
Do you have a notice where you called upon them to explain?
It was there, page 64 it is there,
Page 64 is asking them to pay.
No, so what I am submitting, to Lordship direct them to move an appropriate application.
No. We are setting aside these demand notices. There's no question.
And grant me liberty,
you gave them notices. Proper notices, give them an opportunity.
Lordship permit me further to initiate a proceeding, because he has obtained the money which is excess to his share.
That you are entitled.
Yes, Lordship permission.
There is an unequal admission also, Your Lordship. Extra D.
Granted, you've not given them counsel. Don't just waste time.
They themselves are saying on an extra D that there has been there is no fault of them. They have received the excess compensation. Give me 6 months time. I will return it back.
Where did they say that?
Yes, Your Lordship, an extra D which IA number.
It is their reply, but they have given the reply. Lordship will just see
IA number 231611, an extra D. It's 12th January 2023 letter written by the petitioner himself. All the three petitioners. Page 14, an extra D. This is the Hindi version. Their letter. The translated version is on the very next page. Page 14 and 15. They themselves unequivocal admission regarding recovery notice received now after 5 years of payment of compensation for the land. Lordship is there.
What do you say about this?
Lordship may see that the letter itself. See the letter itself. May I read it?
Themselves are saying, therefore, it is humbly requested to kindly grant us time for another 6 months so that we can deposit the recovery money.
The threats that they say that.
They themselves जबकि हमारा कोई दोष नहीं है मतलब they themselves
You are threatening them with arrest, attachment, whatnot.
So this is
obviously they'll say, give us some time. These are poor people, and you apply the full force of the state to them.
They have received 2.5 crore compensation, whereas they are entitled to only 1.21 crore.
The SLST number 3 in number are aggrieved by the dismissal of their writ petitions, being writ-C number 33513 of 2022 by a division bench of the Allahabad High Court. High Court of Judicature, Allahabad. Before the Chief Justice went to Gujarat, she was at Allahabad. So I saw her name and I thought it was Gujarat. Very good. The issue was with regard to recovery of the compensation allegedly paid in excess to the appellants for the acquisition of their land, in relation to the acquisition of their land for the benefit of the National Highways Authority of India. Research. Having perused the record and upon hearing the learned counsel for the parties, we find that there was no determination of the so-called excess amounts paid, if any, after giving due notice and opportunity of hearing to the appellants. On the other hand, it appears that the authorities unilaterally quantified the excess amounts paid by them, as per their own calculations, and applied pressure upon the appellants to pay the said amount under threat of oppressive measures, oppressive action. There is therefore a clear violation of the principles of natural justice, as it was for the appellants to explain, if they could, as to why there was no excess payment of compensation. Without allowing the appellant such an opportunity, the authorities could not have taken recourse to a unilateral assessment on their own, followed by demand notices requiring the appellants to make the payment under threat. The impugned judgment dated so and so, along with the demand notices issued to the appellants, are set aside on this short ground. The appeal is allowed in the aforestated terms. This order shall, however, not preclude the authorities from initiating action afresh, strictly in accordance with law, due procedure, and the principles of natural justice, to recover any excess compensation,
if any,
actually, if actually paid, after giving an opportunity of hearing to all parties concerned.
Obliged.
The Lordship speak, but this matter I am difficult to not post lunch. Item 16.
16.
1/6. After any day after.
Lord, item 16, your Lordship had fixed the date, Lord, and of course, my Lord, while fixing the date, your Lordship had warned me that it may not be taken up within a few weeks after the fixing. Now, third week we are in. My Lord, the client has come from Chennai.
And he had
But
some
because of that,
personal inconvenience.
Any day
could your Lordship have
Would your Lordship?
any day after 2 weeks. Lord.
I can't say anything further, Lord. So for your Lordships to.
Well, if he has personal inconvenience, then
one other aspect is, as far as 16 is concerned, there are two cases there, 16 and 16.1. As far as 16 is concerned, Lord, I will be raising the question of maintainability of the SLP itself. They were parties to the writ petition.
You lost before both.
Yes, they were parties to the writ petition.
Lord, it's a
Writ petition was allowed. No appeal filed by them. The government goes on an appeal, loses. Now, Lord, the respondent who was a party in the writ petition who had not filed an appeal
They
my
filed.
lord, have come here straight away, my lord. Therefore, the very maintainability of the writ petition, my lord, I mean, special leave petition is in.
Lord, I am the requesting body for which the government.
It may
No,
be.
but you were piggyback riding, is it?
They can't jump.
I agree, my lord. I have not filed a return.
When?
I filed an essay. Any day after 2 weeks, Lord.
What is the difficulty today?
Lord, actually, I have to personal difficulty, Lord. I have to rush home.
It is only the government which will have to, I face the government.
Both of us are there.
Have no difficulty.
Different SLP.
On the ground of personal difficulty, or could learn counsel for the petition. The matter is adjourned. Based on 20th January. 20th January.
It will be on the top, Lord, I'll ask my client.
Matter shall retain its position.
Much obliged.
But I am extremely sorry with your lordship, with your lordship's permission, my lord.
Yes, sir.
Oh, I'm sorry, my lord. Only 20th January, my lord.
You have some issue?
I have difficulty. I will not be there till 28th. Before that, my lord, I will be
13th.
13th.
13th, sir.
I'm obliged.
Yes,
Sorry. But there is some review listed today. If your lordship permits, I wanted to point out something very important, my lord, in respect. Lord Lordship said.
To pass off, Satish.
Honorable Justice Satish.
Yes.
Lord Lordship said, my lord held that a post major notice was not issued and therefore, my lord, liquidated damages validly. What was not brought to your lordship.
That is the judgment authored by Satish.
Lordship is right. Yeah. Lord, what was not brought to your lordship's attention, unfortunately, although it was on record, there are multiple correspondence where parties have admitted there is a force majeure condition. My lord, and similar facts, my lord, considered in an earlier judgment. My lord, I just wanted to point out where.
If you did not raise that issue before us, is it okay?
Lord, it was raised, my lord, in the SLP itself.
But not argued.
Possibly not argued because it's not recorded. Lord, and there is an earlier judgment of your lordship's, my lord. Lord, what happens, my lord, is the transmission line, my lord, is not existing. And my lord, in fact, the other side advised us to seek extension because there was no transmission line. Now we have 24 crores for a non-existing transmission line, and we can't, eventually we have to give it up because there is no transmission line. We can't give it.
Vaguely the facts of the
That's right. 24 crores. Now we are. This is the judgment which your lordships may not have passed on almost identical facts.
What judgment?
An earlier judgment, not your lordships, but an earlier judgment, my lord, identical facts, where again from Karnataka, my lord. These 4 paras, my lord, where the notice of force majeure was not given. And your lordships have held that because the substance of the issue is there, so therefore you need not. Para 39, my lord, is where your lordships have.
This was a matter where we asked for written submissions also, if I remember correctly.
My lord,
it's too late.
Lord,
Looking up at the.
Lord, the only thing is, I would not have troubled your lordships, Lord, unfortunately, my lord, because that correspondence has not been considered, detailed correspondence, my lord, between the parties. Everything on record.
No, but even on merits, we were convinced that this was a case for allowing.
If your lordship only sees that correspondence, that's the only request.
Sorry, Mr.
I'm grateful, my lord. I apologize, my lord, for having done this. Really sorry.
Item number 4.
Please.
Yes.
This case, my lords, your lordships have directed me to get some citation on this. So before I placed citation, the issue was that my lords, no legal notice was served. So under 142 cognizance, while taking cognizance, one has to comply the 138C means. If 138, if you see the 138C says that
NIA.
section 138.
138.
Is the three provisos given. The check number 8 has been presented to the bank within period of 6 months. Now it is 3 months. And number 2, they being ordered due course of the check as the case may be makes a demand for payment of said amount money by giving a notice in writing of the check within 30 days. That has also complained. The last C, the dryer of such check fails to make payment of said amount of money to the pay or as the case may be to the holder in due course of the check within 15 days of the receipt of the said notice. Here no notice is served, my lords. And Rup Singh Rathod says, my lords, all the 3 has to be complained. So cognizance ought not to have taken.
You're not on the issue of delay any longer.
Well, they delay that subsequent. The second point is, your lordship has directed me to file the delay application. Additional document I have placement. There's no reasoning. It's 17 days delay.
No reason at all?
No reason. Not a satisfactory reason. If your lordship can see page 13 means Annex A3. Because at para 1 my lords, he says
suffering from viral fever. Medical certificate is also included.
yes, it's for 2 days. Yes, for 2 days he is satisfied. As per my submission is it's 17 days. Even other ways also, what he has done is, my lords, he presumed that notice is served.
You filed a copy of this unclaimed notice also?
Yes, my lords. Yes, it's not.
That shows that it's unclaimed.
Unclaimed. The unclaimed is not served. It can be either of the two. Further, I have placed the police summons, my lords, where he makes a statement that he's not residing there. Unclaimed can be construed either this way or that way.
What do you mean?
Means in my means he says, complainant says unclaimed means he has served, he has not claimed it, so it is deemed service. My respectful submission is otherwise, because to support my submission, the police also says that I am not residing there, which is at page in the same additional document, page 15 minutes. So there was no proper
Yeah. That's all?
yes, ma'am. Relying on Rup Singh Rathod, ma'am, where it clearly says that, ma'am, page 149 of the judgments.
149.
149.
Yes.
When cognizance can be taken.
Times has really changed the.
Page 149.
149?
They discussed about the when cognizance can be taken. In 149 above, my lords, provided they have quoted, my lords, provided that nothing contained in such. These are the 3 conditions where they have to comply. And further, my lords,
What is the provision which is extracted? Where is the discussion on?
Here, 100%.
There was no discussion. The relevant provisions are extracted.
Yes, my lords. Yes.
You're not showing us where the actual discussion is. You've not looked up that. Where the actual discussion is, you've not looked up.
Lord, I have other map. Just now I got the description, you know, it runs to 47 pages.
Ashrat Singh Rathod is the one which was thereafter set aside, is it?
Yes. No, Ashrat is a 3-judge bench. We have discussed all the cause of action.
No, this 142 jurisdiction place of filing of complaints. This was the judgment which was set aside.
Yes, ma'am. This was the
aside or the later judgment? I don't remember the name now.
As of now, this prevails.
This is the judgment which is
prevails, ma'am. 3-judge bench, because there was some confusion.
Another judgment which was set aside. Is it referred to here?
3-judge bench, ma'am.
No, after this judgment, the amendment came perhaps.
Yes, ma'am. Proclamation. But this issue, my lords, it has attained that proclamation with regard to jurisdiction, because thereafter our trial courts have transferred the cases to the place where accused was residing. So to that extent, they
Third judgment was
there's 2 more on the same issue.
Indicate the paragraph numbers, please.
Yes, ma'am.
Which paragraph?
Yes.
You're going to start searching now.
No, just I have a copy.
Little preparation beforehand would be appreciated. Instead of appreciation in, preparation in court would be helpful for us and also save time. If you could at least prepare your case before you come to court. At least in future, do try to.
I will do.
It's also just put it.
When a second suit is filed,
yes,
partition without disclosing that the earlier suit was withdrawn unconditionally, trial court allows my 711. Now the High Court makes 2 mistakes when it allows the appeal. First mistake, it looks at the version of the defendant to say, as per the defendant's version, after the first suit was withdrawn, certain settlement that was envisaged had not come through. Now this is not flowing from the plaint or the plaint government. So Lordship's test very clearly is the written statement would not be looked into, the plaint would be looked into. But the second mistake the High Court makes is, High Court notices that while the second suit is not maintainable, if the suit is unconditionally withdrawn, it makes that mistake of noticing, that if the suit is dismissed on account of a technical defect, court permits, withdrawal with liberty to file fresh. High Court says this is not a case of earlier that application being required to file, that application not being filed will not come in the way. My lords may kindly see just 2 documents. Earlier suit, which was withdrawn, page 131, was in 2007 unconditional. Page 131.
A partition suit, can you apply the same principle?
Yes, same principle, because the cause of action is the same.
Partition suit can also be filed at a later point of time. You might decide to stay joint at that point of time.
But suppose if the cause of action discloses that at that particular point of time they had abandoned the claim for partition, and in the new claim they say that subsequently on some new cause of action they are asking for partition, new suit would be maintainable. But if the new suit my lord, filed after many years is referring to the original cause of action. But then the original cause of action, once they are withdrawn at page 131, but order 23 directly comes into being. But the new suit, my lord, if I may just show the plain.
Show the plain.
Page 148 is the, my lord, the new suit. No reference to the earlier suit, no reference to the withdrawal of the earlier suit. But page 154.
Yes. What do they say? What do they say about the cause of action?
Yes, no, the cause of action, my lords may see, it starts at page para 14 on page 154.
Yes.
Some 10 to 14, because not 14 is mentioned to be the cause of action, but 10 to 14 sets out the cause of action. All historical facts, same cause of action pleaded in the earlier suit. But I can understand them saying, earlier suit I had withdrawn on the basis of a promise extended to me that there will be a settlement. I withdrew the suit. Thereafter, the settlement did not come through, or they went back on their word, and therefore I am filing a suit for partition. If this was the plaint, my lord, then it gives a new cause of action. My lord's question to me, a new suit would have been maintainable. But what they do, my lord, is they refer to the same cause of action which they had done in the earlier suit.
What was the earlier cause of action?
The same. They are entitled to 1 by 20, my lord, each sister. There are 5
They,
sisters.
they say that the cause of action arose in December 2021 when you refused partition.
That's correct. No, a party.
Whereas the earlier suit was of 2006.
My lords are right. And there also they say that I had refused partition and therefore cause of action arose for the purpose of claiming, my lord, this decree.
What was that memo for withdrawal which was filed?
Yes, my lord. If I may just show the memo. Memo, my lord, is at page 129.
Yeah.
On facts, my lord, I have a different case which I cannot trouble your lordships with. Then pursuant to the memo, there was a settlement, amounts were paid, my lord, certain plot was assigned, even the plot was purchased. But that's all on merits. I cannot trouble your lordships in a 711. But 711 under 11 and A to, my lord, 711 A to D, I must show it is barred by law. But first, order 23, rule 3 and 4 bars the second suit when the earlier suit is unconditionally withdrawn if it is on the same cause of action.
Yes.
But order 6, rule 2, your lordships are interpreted to say that if the earlier suit was not disclosed and there is a suppression, but I was also troubled by the fact that 711 would it be a case for dismissing a suit for suppression? It may be a ground for not granting an equitable remedy. It may be a ground for not imposing costs or coming down heavily. But my lord, your lordships have now held under order 6, rule 2, there is a necessity of disclosing full material particulars. If full material particulars are not disclosed, then 711 can be invoked for the purpose of rejecting the suit, saying that the plaint is not in compliance with order 6, rule 2 requirement of disclosing full material particulars, which in this case would have been the filing of the earlier suit and the dismissal of the earlier suit. So, my lord, this is the second legal ground that I have. But the High Court understands and notices, my lord, that there is a suppression. It says 1 lakh amount to be deposited with the trial court. But that would not be the standard. And my lord, the error, High Court looks into my written statement for the purpose of saying that the plaint may not have disclosed any independent cause of action, but in the written statement you are admitting that pursuant to the first suit withdrawal, you have actually settled their claim and made payments. This shows that there was no partition effected when the suit was withdrawn. So that settlement happened post-suit withdrawal. Therefore, this shows that...
What does the trial court say for rejecting this?
But trial court push it on 2 grounds. Earlier suit was dismissed.
Rejecting the suit?
But page 186, it may not mentions 2 grounds. One is, my lord, they have not mentioned about the earlier suit and the earlier suit being dismissed without unconditionally. My lord, the suit, the discussion starts, my lord, from page 1, from para 6 onwards. Page 189.
189.
This is the question frame.
Whether defendants prove that the plaint does not disclose cause of action barred by time, also it is barred under order 23, rule 1A of CPC, and the result plaint to be rejected as sought in IA. Then it deals with this one after discussion starts from 198 at 200. But it notices that the earlier suit was dismissed unconditionally.
No, but where did this information come to the notice of the trial court if it was not disclosed by the plaintiff?
But I bring it to the trial court's notice. It's not there in the plaint.
Under order 7 to 11, can the High Court look, trial court look beyond the plaint and the plaint documents?
Your lordships have held, there are two things. One is if a suit is barred. One is the suit is barred by any other provisions of law. For instance, today, if someone may not...
But for that purpose, the law itself should be clear, not that you bring in a document to say that under this law, if you look at this document, then it's barred.
My case may be a slightly better case because I am now relying on the record of the court. The court would be
even then,
know its earlier record.
It's an earlier record. That's not part of this suit.
The case, my lord, following the earlier judgment of
to the extent of looking beyond the plaint and
the cause of action that is tried to be projected is an illusory cause of action. Clever drafting trying to create a cause of action which is not there can be
even that can be an inference drawn from the plaint and the plaint documents only.
Plaint documents.
Show us one judgment which says that you can go beyond the plaint and the plaint documents.
Lord, in which case, my lord, I would respectfully request, Lord, I will try to satisfy your lordships on the earlier suit being something that the court can look into. Lord, the High Court is clearly in error, where it now looks at the other material to say that the suit, though it was withdrawn, something remains. I park that aside. Now, in relation to, my lord, the court's responsibility, I'm sorry, it's my lord, what the court's role when it is looking at 711, Lord, the plaintiff comes and files a case. CPC itself has other provisions, my lord, where suits are not maintained.
If you can raise that as a preliminary issue, my brother was just saying that, but not as a ground for an order 7 to 11 petition.
Well, it could be an order 7 rule 11.
How would it be? You can't, the trial court cannot look beyond the plaint and the plaint documents. That is the settled legal position. Show us one judgment which says that the trial court can look beyond that.
In case where it does not deal clearly with this stipulation that
also doesn't say so. That
I agree. But then may I make one request? But this is a matter of some serious importance. Lordships permit me to go and ask the trial court to frame a preliminary issue and deal with
that. You will have to file an application. Why should
you also grants me the liberty?
We won't say anything. You've been in this court long enough, Niranjan Reddy.
They may make
those kind of
they may make one final effort to pursue my lord. Not Dahi Behan, my lord, when your lordships have Arivandanam downwards, your lordships have said clever drafting trying to create a cause of action. No, the plaint itself.
You want us to make those kind of observations now.
No, my lord, but the
we're not going to say a word more than.
But there would be no way, my lord, the court would be able to glean that the.
You raise a preliminary issue, then perhaps you will be entitled to bring in some.
At least your lordship makes an observation.
Nothing at all. That's your liberty under the CPC. You file an application, try to raise an issue.
I have one difficulty. Your lordships may kindly address it. I'll go back and file. Today, my lord, the High Court, in peremptory terms, says, my lord, that the cause of action survives.
The observations made by the High Court shall not be relied.
Sorry.
That's all then?
Yes.
Having heard the legitimate answers, we find that the trial court.
Just one small thing, there's an interim order as I mentioned.
That will wait.
No, as a consequence, I had filed an application here, bringing up record the agreement that has been executed by them because the stay order was. I want to have the liberty to take that in my suit. I don't want it to be said that there was a stay order of the Supreme Court that came in the way, protecting that, entering into that agreement. I don't want that. Because I have a right to bring it up in my suit and say that those agreements should be signed.
Having heard the rules and concepts for the parties, we find that the
trial court, while dealing with an application for order 7 to 11 CP of the Code of Civil Procedure 1900, rejected. Look beyond the plaint and the documents filed over to reject the suit. And the High Court, while restoring the suit to its original number, also committed a similar error. In any event, the suit was not liable to be rejected and the strength of the petition filed under order 711 CPC. We therefore do not find any grounds to interfere with the end result emanating from the judgment of the impugned judgment and order dated 19. What is the date of that? 19?
The 2nd August 24 is the interim order.
Well, no, 19 June, because the sketch pen is 19 June. 19 June 2024. Passed by the High Court. The specially petitions are thoroughly dismissed. Needless to state, the trial court shall not be influenced either by the dismissal of the specially petition or by the observations made by the High Court in the impugned judgment or by the trial court in the order rejecting the suit. The matter shall be dealt with on its own merits and in accordance with law. We further find that, don't say this, the interim order dated
2nd August
2024 shall stand vacated. Any actions taken pursuant to the stay granted by this court, don't say pursuant to, during the period covered by the stay granted by this court, would be liable to be challenged by the party aggrieved in accordance with law.
Arbitration.
You want some observation?
Some suit is of the year 2022. Would your lordships consider directing an expeditious?
The trial court shall endeavor to dispose of the trial as expeditious. Suit as expeditious.
Item number 52.
I don't make his lordship. The basic question will be that whether the contempt petition should be heard by the Honorable High Court or the Honorable Supreme Court. This is a school service commission matter which ultimately.
You'll have to tell us what the case is because
this is with regard to
mention was made in the morning, so I have not read the file.
This is the contempt petition which was taken before the Honorable High Court for non-compliance of the order which was upheld by the Honorable Supreme Court with regard to West Bengal school service matters. Lordship.
What was the order?
The order is at page 3.
Page?
Division bench order of the High Court which upheld by this court is page 1A.
Page 1.
The division bench The High Court, Supreme Court's order is at page 42. Division High Court, Supreme Court order.
This order of the High Court is dated 7th May 2025.
Yes, which was upheld by your lordship, which is at page 345 by your judgment dated 3rd April.
That was that by Saki Bhatta. By Saki.
Yes, by Saki, that's the same matter.
So, this contempt was instituted in relation to which direction of the High Court?
One, non-uploading OMR sheets, not recovering the money from the persons who have been found to be specifically tainted by the High Court.
Now, what does the High Court say in this impugned judgment?
313. In the
not maintainable before this court to implement the order which merged.
But in a similar situation, this court in 2014 was on 16 SSC, else, in spite thereof, the High Court should entertain the contempt. This judgment was delivered after.
Let the High Court deal with it. In any event, the other learned judge who seems to have taken up the issue of whether the judgment of this court, the directions of the division bench are being implemented properly or not. So that is one issue. There seems to be
what has happened is the judgment says that since there is merger of the order of the High Court with the judgment and order that your lordships have delivered in Vaishakhi Bhattacharya, therefore the contempt, if any, can only be that of the Supreme. That's the basic point.
That is what the division bench has said, no doubt, which would ordinarily be the principle. But now, because the High Court is already looking into that issue as to whether the uploading of
compliance, the High Court can go into, but contempt it cannot go into. That would create a precedent.
What are the directions though?
Yes, the directions your lordship will find it.
Because if there are any extra directions that we have given which
Yes.
were not there in
Yes.
the High Court order,
Yes, my lord.
then you point it out to us.
No, but they want, my lord, there were certain directions which your lordship didn't give.
They seem to have only said that they are violations of the order passed by the division bench.
Yes, because my lord, your lordship did not, my lord, put every direction into your lordship.
We have only confirmed most of those directions.
Yes, I am not at all arguing that. I accept that.
So let us, if we only confirmed it, we will say that the High Court can look into it.
Not contempt.
In exercise of consent jurisdiction.
No, my lord, your lordship, that is creating a precedent which will be very, very dangerous.
We'll say that under 142 we did it.
No, my lord, in 142 every other case will also be like that.
If it is a
My lord, I am not, please, my lord, I am not saying that we are either in contempt.
Better off.
I am prepared to tell you lordship what we have done and what is yet outstanding.
Gupta, you may be better off before the High Court.
I wish to be better off, my lord.
I may tell you that when I was at the High Court,
in my matter it is laid down that the contempt of a Supreme Court order can be dealt with by the High Court. But I would not want that.
Mr. Gupta, when I was in the High Court,
your lordship must keep in mind.
Listen to me at least. You're not even willing to listen. When I was in the High Court, we had this practice of the judges who retired, their contempt cases being passed on. So I had the contempt cases of a particular judge who had retired.
That's given in the High Court rules. The High Court rule says that when I retired, must go to some other.
I'm telling you that perhaps you'll be on a better footing, not you, your clients. You might be on a better footing before the High Court than you are before me. Because I am extremely strict in contempt matters. If you're willing to take that risk, then we'll keep it here. I face the music thereafter.
Because face the music.
You are the officials of the Service Commission or
yes, I am for the
government.
There is only for the
well, all of you seem to be in the same boat because all of you keep on trying to smuggle in the tainted candidates one way or the other.
Nothing of that sort is.
We have seen those orders, Mr. Gupta. We have seen your attempt before the High Court, even after our judgment, to try and bring in tainted candidates. If you have not seen that judgment, we would advise you to look at that before you.
I have seen the judgment.
Before you put your clients' necks under the Damocles sword before us.
So if your lordship may I make only one submission? It is an extremely dangerous precedent to say that a Supreme Court order can be looked into for the purpose of contempt. For compliance, yes.
We are not asking them to look into our order.
Yes.
The judgment, to the extent that we have confirmed the directions of the High Court, those directions alone.
That would go against, Lord, every judgment of your lordship's court, Lord, which says that there can be only one order and it is the merged order. Now, your lordship wishes to, Lord, look into that.
Let them face the music here. In spite of our telling them, if they want to face the music here, let them face it.
What question? Then, my lord, can you then takes up the control matter? Take it up.
Issued notice already?
Yes.
Notice has been issued?
The notice.
Have you filed your counters?
No, not yet.
Why?
In spite of directions, they did not. We've got complete instructions, my lord, for the SSC here. There is only one aspect on which we are unable to, my lord, take up the matter just now. Because we are in the process, my lord, of lordship's order.
Last opportunity is granted to the respondents public contemners to file their affidavits within 3 weeks. This one does therefore, if any, will be filed within 2 weeks thereafter. List on, we'll take it up on a Tuesday or a Wednesday.
Yes. But the content has to of it.
28 January.
That the contempt petition was also filed.
We'll give the diary number. We got the separate contempt petition. We'll give the diary number.
So I see those will have to be
tagged. That can be tagged. I'll just give the diary number.
Affidavit because relating to the contempt petition, that is not the one of the things.
No, they said
this is not the contempt. This is only the
SLP. This is the SLP.
You filed the separate contempt case.
I'll give
which are not listed today.
I'll give the.
Don't say contempt now.
Diary number. It has not even been.
We'll give the diary number. That will be tagged.
Is it defective?
It's defective. Because
why have you not cleared the defect?
This would have.
Why have you not cleared? Or because you want it.
So the diary number will give.
Then this can be disposed of.
No,
you want to keep this pending.
The content should also be taken up along with hearing of this matter. Ultimately, the affidavit which would come, we should take.
This affidavit also might be there. Very. Then tag with.
I will give the diary number in a minute.
So and so. after the defects therein are cured, steps shall be taken to cure such defects within
About a week.
2 weeks.
2 weeks. Give yours, we'll give it. Much obliged.
If you
36401 is the tally. 3640.
36401 of 25.
Great, your man. Much obliged.
54.
Without issuing notice.
Rejoinder.
Your Lordship had not issued notice, but we put in a counter.
We've seen your counters, but rejoinder has not been filed.
Rejoinder is ready. I'll just, if I
You cannot bring the rejoinder at 11th hour, Mr. Gopal. We had indicated the time frame in the order.
I inspected, we have got the rejoinder just now.
Sorry, Manoj, the counter.
Your Lordship will be disabled, but we have the rejoinder, we can go on.
You got it just now.
Yesterday night.
Yesterday night. We've not been
Your Lordship
given
will not be able to get
Sorry, Manoj, they filed it beyond time. That's why. But Manoj, between
Then let's foreign
we have no dates left in December, so you'll have to wait till January.
Well, they want to.
What is it? We've not passed any orders.
That's true. That's true.
Whatever process you want to initiate, you can
do one thing. A strategic sale which happens pursuant to the order. Nothing happens to them. What has been released for my exit, you have to sell. For that sale, nobody comes because of pendency. They know that. But I give you also the reality of the ground. Moment Supreme Court is pending, no buyer will come, and they want to hurt me like that. They have to do one thing. Would my lords give me just 5 minutes after we argue on this? I have one chart. I'll only show one chart, and all the findings are in one chart. In a foreign award, there is a triple finding, triple malus award, Singapore High Court, and Delhi and the other High Court.
Those, but to tell you the truth, I did not have enough time to go through your counters. So at length, they are quite.
I don't want that. I don't want that.
Quite voluminous.
Have it on a Monday, Friday next
one day would be better.
May I just say
but
Monday.
I don't know which one.
Friday comes.
15th is only Monday.
15th is there is a matter.
Whatever Monday, Friday, Lordship gives.
Two matters are.
You'll have to wait till January, Mr. Smith.
There is one Monday, Friday, any Monday, Friday.
Next Monday, I'm not there.
Friday.
One Monday after that. Friday, it's not possible. We'll have to read these. At least get a gist of what you've said in your counters. You don't keep them brief also. So what do we do with that?
The only request for any date this side.
This side is practically impossible.
This company is losing value, strategic sale, purchase are not coming, and they are getting their way.
5th January. So that way we will have the week before that.
Manoj, between a try and a try, Manoj, may I make an offer?
Offer? Yes. To them or to us?
Obviously, Manoj. But I intention between a
I thought the offer would be withdrawing it. That would be a good offer for us.
I'm sorry.
I will put it to them. Your Lordship is giving a longer date. I don't think it will work, but we put it to them. Sale of share, this, that, etc. There must be a scheme to the deal. I'll put it to
Then
them.
we'll put it to you.
Yes.
Great. Let's on 5th.
But with the offer,
Rejoinder.
the copy without prejudice. Please trust.
I'm not committing anything. I'll put
Yes,
it
of course.
We're not saying anything at all. Yes.
Well, imagine the reasonableness. We said so last time. We want exit. You have a problem about it. You get a buyer. You sell my shares. Give me the money and say goodbye to me.
This offer about whatever.
What is all now?
Chief to suggest we can have a buyer for the whole company.
You sell it for me.
Suits us. We have given 300 crores. We have to get 600. Sell out the whole thing and give me. You get a buyer. No problem.
But it can't be that you don't pay me damages, you don't sell, and I'm stuck.
Anyway, well, we'll see. You also see it on 5th.
No, but here, what do they say about who's going to fine?
We have to find collectively.
Following settlement.
Collectively,
It's not a swayam.
Your Lordship will just keep it for the time.
Rejoinder. You filed it already or you?
He filed it yesterday.
Confirmed that the rejoinder was filed yesterday.
Yesterday,
But we did not find the same on record. One rejoinder or multiple?
one rejoinder, common rejoinder.
One common rejoinder was filed yesterday.
Great.
We did not find the same on record. Please verify and put up the same. So it's based on 5th. Yes.
It's a promising beginning of the new year.
The first day of the yes. Let us see how it is.
Right. I'm sorry, Malone, about the rejoin.
Item number 17.
17.
I beg to appeal for the petition words. When your lordships, you should notice, they had pointed out that this Vesting Act does not apply because the 49 Act does not apply. First page of the High Court order says 25 acres. The 49 Act is basically ruling over matters in which there are 100 acres. If the 49 Act does not apply, the definition in the Vesting Act does not apply to me.
How do you say that the 49 Act does not apply?
The lordships have considered this in. Firstly, it's been considered in the case of State of Kerala versus Popular Estates. Secondly, Milords, the Act, the 49 Act, may I just give the copy? It's a State Act.
Yes.
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 1, Clause 2, Placitum 3. This is admittedly in Malabar district having a contiguous area of exceeding 100 acres is what the Act says.
Private forest situated in other areas in the northwest. Yes.
My case is 25 acres. First page of the High Court's order.
You are in the Malabar district?
Yes, Lord, that I am. I am on 125. I'll take your lordships to page number 2 of the High Court's order if your lordships are permitting me.
One moment, let us see the explanation also. The forest should have a contiguous area of 100 acres, not your individual landholding as such.
This forest is not there.
So is the forest here declared as a...
This matter, forest is also not there.
There's no forest?
No, not to the extent.
There's a state government declaration?
No declaration.
There's no declaration. Who appears against?
There was a declaration, that is why they approached the Forest Tribunal under Section 8 of the Act for exemption under 3.3 or 3.2.
Not
produced. No.
You went before the tribunal.
1971 is when the declaration ought to have been there.
So why would you have gone to the tribunal?
1999, Milords, I can go to the tribunal saying that I have not declared. In 1999, when they interfere with my possession, saying that this has been vested, because if your lordships just permit me to make a statement, that is in the very many ways in which land is taken in eminent domain, Milords, vesting is perhaps the most cruelest.
But don't we have the declaration before us? There is a declaration. Why have you not placed it on?
That was never in the
Well, now he's saying that there's no.
I went to say that I am not vested. I went to say that I am not declared. Milords, the first time I went to the tribunal was with me insofar as 6.68 acres was concerned. The tribunal remitted back the matter. Unfortunately, I went on appeal, I failed, Milords.
Is this issue that it is not declared under this provision?
My lords, when saying that I am not covered under the Act, which is exactly the same, I went saying that it's not vested
in. What context did you say you're not covered by the Act?
My lords, I have gone saying.
You're pleading before the tribunal, let us see what you say.
Yes, my lords.
Application is not produced.
Application is also not.
Your lordships, kindly see. 102.
We don't have your application before the tribunal.
My lords, it's
half-baked filing is the norm here, of course.
Endeavor to see that the arguments are not.
No, but we'll have to draw an adverse inference from whatever document has not been filed. Obviously, it is against you.
With the utmost apologies, Lords, I'll produce it.
These are old matters, so we'll have to let you do that now. Fresh matters, we're not allowing it. You will not build up your case and as you go along.
I'm not building it up afresh.
No, you're not. You approach the tribunal, you don't give us a copy of the application that you filed before the tribunal. Now we are dealing with what the tribunal said.
I can only read, just to give you a lordship that I'm not building up my case. If I read 101, ground R, the finding of the learned tribunal that the possession of the property by applicant was disturbed only in 18/3/1999 And that as on date there is no cultivation, it negates the intention of the owner to cultivate the land as on the appointed date. My lords, my submission is that it is interfered only in 1999. I have loans in my favor for cultivating the property, saying that I'm already cultivating in 1994. The act should apply to me on the appointed date, which is in 1971. It all doesn't fall in place, my lords, for the act to be applied on me. I bow down to your lordships. I'll bring the application to draw more clarity.
And you also get a copy of the declaration, please. I mean, we'll at least need total clarity and comprehensive
As and when the application is filed, your lordship will be clear. Because they have challenged the notification.
But what if there is a declaration, please bring it. For the petitioner, seek some time to produce a copy of the application filed by the petitioner before the Forest Tribunal. And Council for the State of Kerala shall also produce the declaration under section 1 in brackets 1 within brackets 2, is it? 2 within brackets 2 within brackets small I.
Yes, lords.
Of the Madras Preservation of Private Forests Act 1949, insofar as it pertains to the petitioner's land. List on third page.
Item number 18.
Yes. 18.
Please, minutes. I appeal for the respondents.
Yes.
Madam, may please see Annexer R1. Subsequent development. Then Annexer R1, the counter was filed, we have filed there. R3.
Which page is it in the counter?
I am referring to page 13.
13. What is this order?
This is a subsequent development wherein they filed a writ petition and wherein High Court has stayed the order of the which was passed in my favor, the inquiry order.
Because there are some dispute regarding the age of Savitri Devi.
Yes.
Mother of the petitioner, my lords.
What is this 15/3/2024 order?
15/3/2024 is an inquiry conducted by the and an order has been made to issue a death certificate.
Where is that order?
Well, that has not been placed on report. So this would,
without seeing that, how do we understand?
Well, I just wanted to say that means because of this, either the matter has to be adjourned or I need to file a rejoinder. That's what I wanted to point out because this is a subsequent development further to the filing of the petition, and I come to know only this when the counter was placed on.
It's been passed by the subdivision registry.
Yes, may I clarify, my lords?
One moment. Died some 30 to 35 years. Put in some producing or put it. (18/1/2024) showed that Savitri Devi died 30 to 35 years ago.
Yes, my lord.
Is that correct? But in spite of that, this 15/3/2024 records her date of death as 23/7/2005.
My lords, what the petitioner had did was they applied for a death certificate of Miss Savitri Devi. But the High Court was of the view that the death must have occurred some 30-35 years ago. The certificate cannot be granted for the year 2005 because the death apparently did not happen in 2005. That is why the order of 15/3/24 was stayed, my lords. This is what this order of the High Court has said.
You already took time to
file a rejoinder, my lord.
You took time earlier. You took time earlier and you did not file.
I could not get the documents from the High Court because I have only been served now regarding this High Court petition, etc. So I need to place it on record. Even the memo parties are also relevant because there are so many parties. I will be R7 and R8 before the High Court.
There is a status quo order here.
Yes, ma'am, that is continuing. That is dated 6/11/2022.
Well, it's Barilal, they are alleging that I previously
related to Madan Lal also.
No, not related to Madan.
Not related.
Not related.
But according to the
According to me,
according to the
they are the
petition,
wife of Barilal.
she is married to Badela. That's accepted by the High Court.
No, my lords, that is not accepted at all, my lords. My lords, may please have a look at the influence order, my lords.
The appellate court allows it.
Appellate court.
Appellate court allows it.
Yes, my lords.
Your writ petition, you succeed.
In my writ petition, I succeeded, my lords. Para number 15, the High Court records some relevant observations.
Para
15.
Yes.
My lords, in view of the admission made by the sentence that starts from in view of the admission.
View of the admission
made by the answering opposite parties in their counter affidavit with regard to the same, it is absolutely apparent the reliance placed by the appellate court on the state family register, the family register of Mr. Barilal, that initially stated because they had filed a family register, they had applied for it, they said that the family register of Mr. Barilal finds the name of the respondents, that are us. But afterwards, my lords, an order was passed on 5/7/2017, my lords, which is on record in the writ petition as in the SLP as well. The names of the respondents, which is us, was struck off from the family register of Mr. Barilal.
Where is that order?
Because that is page number 46, annexure P6. 42. Page number 42, P6.
That's not the order, that is amended.
What is the last column states of the order as well. Remarks in the remarks section.
It is in view of the order dated so and so. Name of
Kalabati, that is the respondent, my lords.
Where is that order? That 2017 order is not there.
No, that has not been.
That is not. But the High Court seems to have seen it.
Yes, my lords.
Why is it that you didn't produce it here then? Was it not produced before the High Court? The High
It was
Court
produced before the High Court, my lord.
Then it must have been available at that point of time. Why is it not available now?
My lords, in that case, I may be permitted to
file a copy of that.
Yes, my lords, absolutely.
And counsel for the petitioners, it's some time to file a judgment. Last opportunity is granted to him to do so by the next date of hearing. And counsel for the respondent shall place on record a copy of the order dated 5/7/2017, which finds mention in para 15 of the improved judgment. Based on 10th February.
Oblige. Oblige.
Item number 20.
20. 20.
Item number 20.
Respondent have 5 years.
Yes.
And for the petitioner bills. Because my learned in this find is counter minutes, matter can be heard minutes. Because in this matter, what has happened, Mirrors, a sum of rupees 5 lakh was borrowed from me, in lieu of which, Mirrors, a promissory note was executed. Now, Mirrors, when the money was demanded back, Mirrors, the money was not paid. I was constrained to file a civil suit. Mirrors, went before the trial court. Mirrors, the trial court gives two findings, Mirrors. Firstly, Mirrors, that I have failed to execute, I have failed to prove the execution of the promissory note, Mirrors. And the one finding, Mirrors, which is given is against my learned friend that the partnership firm was in existence, was a registered partnership firm, and all the three partners were partners of that firm. Mirrors, another finding which was given is regarding the financial capacity, Mirrors. Now, Mirrors, when I went in appeal, Mirrors, what the High Court does is that Mirrors, High Court goes on the footing that firstly, the trial court rightly appreciated the evidence that I have not paid, I have failed to prove the execution of the promissory note. Now, Mirrors, please come to page, for a moment, Mirrors, page 8 of the Mirrors impugned judgment. Now, Mirrors, paragraph 9. May I read, Mirrors? What the High Court says is, Mirrors, the court has rightly noticed, Mirrors, fourth line of the para, Mirrors, page 8. Your Lordship has it?
Yeah.
Yes, Mirrors. Now, the court has rightly noticed that the evidence of PW 1 and 2 does not inspire confidence and is insufficient to prove execution of Exhibit A3, that is the promissory note. Now, Mirrors, PW 1 is the daughter of the original plaintiff. PW 2, Mirrors, is a direct witness who was also present. Therefore, Mirrors, evidence of PW 2 was simply rejected without any reasoning, without any discussion. Now, Mirrors, with respect to PW 1, the High Court gives a finding that her evidence is not reliable and is artificial in nature. Now, Mirrors, may please come to page 51. That is the promissory note. This was the promissory note which but the entire transaction as to who has given the money, to whom the money has given, what is the purpose for which the money has been given, Mirrors. The Lordship has it in Exhibit P3.
Yes.
Mirrors, may I read? Promissory note executed by Baiju, PS, managing partner of Messrs. Ideal Bankers, so and so, and on and behalf of Messrs. Ideal Banker. So, Mirrors, this was executed on behalf of the partnership firm, not for an individual, and is executed by the managing partner who has all the right to sign, Mirrors. That I will show it from the partnership deed, Mirrors. To K. Girija Sivaraman. Mirrors, thereafter, so and so, full stop, I and other partners, Mrs. Padmani, that is respondent number 5, wife of so and so, and Mr. Dharamrajan, Mirrors, he was another partner, have received rupees 5 lakh. A due acknowledgement is there that rupees 5 lakhs have been received by way of this promissory note, Mirrors. Today, from you, today, and on behalf of our firms, Messrs. Ideal Bankers, Mirrors, I promise you on behalf of the firm that the partners, that the above said 5 lakh rupees will be paid to you with 12% interest on demand to you and to your order. So, Mirrors, the entire transaction has been recorded in the promissory note itself. Now, Mirrors, we see at the bottom, dated just below this, Mirrors, it says Baiju PS, managing partner, Messrs. Ideal Bankers, Mirrors. So, Mirrors, it has been signed, it has been stamped. It is not that it is only signed, it is also stamped, Mirrors. Now, Mirrors, on the right,
make out anything there.
Mirrors, on the left, that is the seal. Mirrors, just above that,
your copy is better. Show it to us because we can't make out a word here.
Mirrors, it's not legible.
Only Baju's signature is.
Yes, Mirrors, I'll stay on.
Beyond that, there's nothing else.
Yes, Mirrors, I'll stay on that, Mirrors. So, Mirrors, what is written over there, Mirrors, that has been executed by
someone else also seems to have signed it.
Yes, Mirrors.
Who is that?
Mirrors, that stamps have been signed by the Baiju only. That is the managing partner.
No,
so he has
signed on the left side of the stamp.
Left side of the stamp.
Signed on the right side of the stamp.
These signatures are only of Baiju, Mirrors.
Why so many? They're not tallying also.
Mirrors, we see PS Baiju. At one place he has written complete PS Baiju. On the right hand side he has signed on the stamp and the paper.
Oh.
So therefore, Mirrors, only half of the signature is being visible. So, Mirrors, the promissory note records the transaction. It has stamps. It is signed by the managing partner. Therefore, Mirrors, it itself has an evidentiary value in law. Now, Mirrors, secondly,
he remained ex parte. So
he remained ex parte.
Written statement.
He remained ex parte.
Filed the written statement.
Mirrors, respondent number 5.
5 mark.
And the legal heirs of Dharamrajan, the another passed away partner.
The firm continued.
No. Firm, Mirrors,
did not continue thereafter or continued, my learned friend can answer that better. But since I have come to know,
you filed the suit against the firm.
I filed a suit against the firm and all the
partners.
And all the partners,
And the firm, who appeared on behalf?
Nobody appeared on behalf of the firm. Only the partner appeared,
Partners, two of the partners.
One partner was there,
presented by LRs.
Yes, the another partner represented by LRs.
Baiju remained ex parte.
Baiju remained ex parte.
He was alive. He's still alive.
Back then he was alive. Now he has passed away. During the pendency of the appeal, before the High Court, he passed away. Now, we come to the evidence, page 64. This is the evidence of original plaintiff. Now, one of the findings of the trial court is that she did not appear in the witness box. Therefore, an adverse inference is to be drawn against her. Now, my submission is that your lordship will straight away come to evidence of PW 168. That is a daughter. Now, trial court says, I will not believe your evidence for the reason you did not have personal knowledge of the transaction. Now, just see page 68.
You say that you were present.
I am saying that it is. I was present over there, and the entire transaction is personally known to me. Please, I'll read second paragraph. After where I mention the details of my name. I am the power of attorney holder and daughter of the petitioner in the above mentioned suits. All the statements made in the above mentioned suit is true, and all that matters are personally known to me, and the plaint should be this should be considered as part of this affidavit. So, I was personally present over there. I had personal knowledge of the transaction that I will show it from the evidence also, Now, your lordship may come to.
No, what? Which page are you referring to?
It's page 68 and exit 39.
8 is what?
This is the evidence of PW1,
It's Girija Sivaraman.
Yes,
Your name is Rashmi.
Miss Reshmi,
Then
she's the father.
Look at the top of page 68. It says Girija Sivaraman.
Yes, there is some
represented by power of attorney holder.
She's the power of attorney holder. There is some mistake.
Evidence has been given by the power of attorney holder.
Power of attorney holder.
So, but you don't speak as yourself. You speak as.
There is some mistake in the translation because what has happened is that the entire proceedings were in Tamil.
I was wondering why her name is there. If you are the witness.
I'll read this sentence again. I am the power of attorney holder and daughter of the petitioner. So, therefore, that clarifies that it is the statement of evidence of Reshmi. I'll start from the bottom of the page 68. Believing the defendant, the plaintiff has given an amount of rupees 5 lakhs on 10/8/2001, and the amount has been received by 2-3 defendants and the late partner of this firm, Dharamrajan. I testified that amount of rupees 5 lakhs was given.
No, where do you say that you were present there?
Yes, I'll show it. I will show it, we come to page 70. Last paragraph. As my mother is under treatment after a kidney operation, she cannot bear any stressful job, so and so. So I have become the power of attorney holder in this case. I will continue with the case and all those things. After the full stop, the plaintiff has signed the pro note in front of me. My husband, Krishna Kumar, Sridharan, Sham, Santosh have seen it. Plaintiff received the money after so and so. So I say that I was present over there. I say.
The plaintiff has signed the pro note.
No, it's not plaintiff. The plaintiff, this is the translationer. This is what I'm saying. Because documents have been translated.
Where?
Actually, it has to be defend number 2.
We don't know what it says. If it says the plaintiff, then your case falls to the ground straight.
Exactly, I also
we don't know what it says.
Very much difficulties in reading these documents.
What?
Yes, what I am trying to say is that I was present over there.
Malayalam, is it?
It's Malayalam.
The position is also in Malayalam.
In Malayalam.
You've looked at the original? You understand Malayalam?
Yes, I understand Malayalam.
Have you seen the original of this deposition?
Yes, my lord, but
does she say, I saw the defendant sign in front of me?
Yes, their case is that the defendant has signed in front of.
What did she say in the Malayalam version?
Lord, as of now, Malayalam is not with me, Lord, because her case is.
You must have noticed that there's a mistake here, at least. At least there is something here. Did you not look at the original then? No. Produce the original, please.
Please, I'll produce the original.
The original deposition. of PW1, Reshmi, what is the full name? That's all.
Reshmi.
Reshmi shall be original deposition of PW1, Reshmi in Malayalam shall be placed on record. Placed on. Along with the proper translation.
Proper translation. So I believe so.
Placed on 3rd February.
So grateful towards.
Number 21.
Yes.
Your Lordship, Giri sir has to be here. He is in legs on court number 5.
You can make a beginning
for
then.
adjournment.
You can make a beginning, madam.
Sorry?
You can make a beginning. He will either come today or you can
It's
make
a-
the ending also yours.
It's a part-heard matter, Your Lordship. It will take time. Please grant a short adjournment.
No adjournments on.
Then
We have now been asked by the Chief Justice not to grant adjournment.
please grant me a short passover then.
Not in the afternoon.
Please.
So whether you like it or not, the ball is in your court. So you might as well start. At some point of time, you'll have to start arguing, is it not?
Your Lordship, I'm not well versed with the facts.
Why? You're not attached to the office of the senior counsel. He doesn't let you read the briefs.
No, I have read the brief.
Then if
but
you read the brief, then you can make a beginning.
Let the respondent side start.
Now you want to give up your advantage. That is worse. Should never ever do that. It's your advantage being the petitioner's counsel to make the beginning. You let them have the first say and then prejudice us against you. Mr. Nagamuthu is very capable of doing that. Make a beginning.
I will do my job, not concurrent findings by 2 courts.
If you have read the file, you know that there is nothing in your case, right? There is no evidence of payment of the land cost. And there is no no proof with the respondents either. That's why division bench has dismissed your appeal.
And the passover to that senior wants to say something.
No, what senior you say?
Like
Tell us about this.
Senior on his legs before court filing. Giri sir.
Madam, whatever, please begin.
Your Lordship, I'm
No,
not
but that will, then it's a case for dismissal then.
No.
Let your client take.
No, Your
What to
Lordship.
ask?
It is an important matter to the client. I would
Nothing
not like.
important. You answer this query if you have read it.
I'm
You
not.
cannot seek an adjournment like this in final hearing matters without notice to us. Both of us have gone through it. We are ready with the matter. We are telling you the facts of your case. And you
Your
are just
Lordship,
standing.
grant me a short
No, no.
passover then.
No, madam, please begin.
Lordship, it's a state matter. I cannot make any submissions.
Fine.
Please be lenient.
It is dismissed then.
The Chalan of 1973.
Two courts are held, that I paid in 1973. I produced the receipt.
Yes, Mr.
But
We just forgot that it's a state's
It's
appeal.
the other way
The
around.
burden is on, she rightly said that you have to explain. Yes.
Page 110, how do you get over that?
But two courts on verification of the return found that I paid the amount.
This Chalan is on the face of it doubtful is what the Treasury itself says.
They do not say.
The Treasury itself doubts the genuineness of the Chalan.
No, you ask my kindly.
There is a question of your saying that you paid it.
Very short order of the division and I will also take a lot of the single digit order. It was never the case that we have not made.
But rightly she wanted to place the ball in your court, obviously. Because I did not realize that she is appearing for the state. So your Chalan is doubtful on the face of it.
No, it is not doubtful. Two courts have held it is acceptable. Two courts. You have kindly come to
the Treasury, once it doubts your Chalan, there is a question of the courts giving it a higher value.
Courts have not held any doubt. Nobody has raised any doubt. You have kindly come to the order. You have kindly come to the order. This is a long-standing proceedings. Where originally I claimed I asked for Patta for 4.02 acres. They said that's no.
Yes.
Originally I asked for Patta for 4.02 acres.
After encroaching on it. Yes.
No, then
you were assigned 1.62 hectares. Very well. Mr. Giri, you're back. We had reversed your roles. We thought you were for the actually I didn't look at the cost title there.
It's for the state.
So, you're for the state.
But I was requesting an accommodation for today, but if your lordship's feel.
Why?
It's got to be aparted.
In any event, the ball is in his court. He needs to convince us that.
That's what I'm worried about.
Tomorrow. Tomorrow, sir.
Tomorrow is okay.
Tomorrow, Wednesday again, we'll have
Thursday. Thursday is okay.
Anyhow, we've granted you a stay, so you can. Stays in your favor.
Yes, yes, yes.
You'll still have to convince us that this Chalan can be acted upon. 1973 Chalan, but
I produced the Chalan. Two courts were accepted. They do not dispute that.
Please tell us how to get over page 110 then.
They do not dispute.
110, the Treasury says this Chalan is doubtful.
But doubtful means they have to verify the government records. They have got the government records. But I will convince you that.
Very.
Tuesday.
Today is not very auspicious.
Next Tuesday.
No, not this month now. Once it will have to go to February perhaps, 10th February. The interim order dated 19/5/2025 shall continue.
Please encourage your juniors also to argue.
At least strong cases. I mean, for the state, this is such a strong case and she doesn't want to make a beginning. Because of her trepidation, we thought she was appearing for that, for Mr. Nagmuthu's client.
The state has got a weak case.
You would of course say so, Mr. Nagmuthu. Why would we have granted a stay? Unless prima facie we were convinced.
Prima facie it may be correct.
Yes, that's why we said prima facie. Let us see how well.
Originally, I got a very strong case.
We'll see.
Great.
Maybe, but
the petitioner Willard is enjoying a stay, but is not serving the third respondent.
But it's
the
interesting
third
that
the transaction
despite
between
appearance of, this is very strange, but it's despite appearance on 2 occasions, they take time to file the reply. They don't bring on record their counter, but they're more worried about the process. Now, insofar as the process is concerned, I'll also point that out.
What happened to R3? You still not served.
I appeal.
The bank and the RSP was the borrower.
I appeal for respondent number 3. I've been opposing my application before NCLT.
Counters.
No, I am appealing. We could not file it. My counter is ready, but we could not file it. I can ask.
Yet will say
without that,
the process
3 will be required to be here.
No, I am appealing for respondent number 3. If their argument is that they are adopting what R3 is going to say, then the right should be forfeited.
Someone stay for R3.
Yes, yes, I am here for R3. I am appearing to respond.
Yes, Millet, I have served them. That's what I'm saying, Millet.
That's you need some time. Do you need to file a counter?
No, I don't need to file a counter.
Don't need to file a counter. So you also don't want to file a counter.
Well, I am the RP, my lords. As such, I have no role left after the plan is approved, but I'll assist my lord since I was the
That
person
I
assisting the
would
court.
have the benefit of his assistance also, Millet, in the sense what is he bringing on record? Because Millet, he's before NCLT, before NCLT, Millet, he's been opposing my application. So therefore, Millet, anything that he has to say, which is my petition, has to be brought on record by way of an affidavit.
I've since discharged. It's now for the SR.
You're discharged now. SRA is already.
I am the appearing for.
You are for the
Yes,
SRA.
your lordships, but that's all. The substantive counter is to come from them, my lords. No?
This today, as per our instruction, the loan stands regularized.
Why was that sale deed held invalid?
So far as the sale deed, in fact, what had happened is NCLT had appointed a court commissioner to render a finding with respect to whether these units were in existence on the day when the sale deed, the conveyance deed was executed or not. She comes back with a report saying that these units prima facie appear to be in existence on that date. Yet, that report is completely discarded and my application is dismissed on the ground that this is primarily an issue between you and the borrower. The corporate debtor is not a party to the agreement, therefore, sorry, there can be no other path on your application. Dismissed. Which in fact, on the first date when the matter was listed.
What about your counter?
Because I'll file it. It's ready. We just need.
Which respondent are you?
For two. Respondent number 2.
2 is SRA. Very good. Respondent number 2, the successful resolution applicant seeks some time to file a counter affidavit. Respondent 3 is now served and is represented by the counsel. What is your name, counsel?
Rahul Malhotra.
Mr. Rahul Malhotra. R1, you will not be.
No,
R1, the resolution professional states that he has been discharged and would not be filing a counter affidavit. Based on 17th February.
So grateful for it.
September 23.
Millet are giving a date.
17th February. Yes.
So this is a matter where the Honorable High Court Manoj said, reinstated the original interim order saying you cannot demand 21 odd crores from the NBFC. The respondent is the NBFC. I have already initiated proceedings prior to filing of this suit before the NCLT under the RBI Act. They subsequently file a suit, simply set up just have the suit is very interesting.
What happened in the first appeal now?
First
appeal is pending. The matter is pending and that has to be decided by the Honorable High Court.
This interim order which was passed?
Yes, interim order says you cannot demand money and in the original suit, the claim is permanent prohibitory injunction.
Have you entered appearance before?
We have entered appearance.
Have you asked for vacating of this interim order?
My understanding, not that matter was listed yesterday also.
You've not filed an application there.
This is an appealable order, not
why should you?
Your lordships.
You came here saying that it's an ex parte interim order. That was your complaint, is it not?
That was a complaint. Was also purely on point of law.
No, but if you've already entered appearance there, you might as well pursue the proceedings there. What is it that we will do at this stage?
Just hear me for 1 minute. In a suit for permanent prohibitory injunction, exact same relief granted in the interim.
Not for us to say anything on the merits of the matter at this stage. The matter is pending before the High Court. You have to pursue it there.
And even this itself is an appealable order, Lord. It shouldn't have come directly to your lordships. But the matter is pending, as your lordship says, before this court. And you can apply for vacation of this order. That can be decided, Milord.
Bear for 1 minute.
What was the suit?
The suit is yes. P10. The prayer is at page 65. Lordships as well.
But we can't decide the appeal here in this SLP.
Well,
right?
all- well,
You want us to hold that suit is not maintained.
No, Manos, not that. I know Manos, not that. Manos, no, Manos, not at all.
We heard expeditions
Manos,
were
can an interim order in the nature of, which is exactly in the nature of the filing
This is an ex parte order. You have entered appearance, file an application seeking vacation of this state.
Manos,
You've not done that till date.
Manos, we were hoping that either that gets heard, Manos, we were hoping, Manos, because what they're doing, Manos, is before the NCAT, they are saying proceedings are straight, everything is straight, you can't proceed. Manos, that's very interesting. An NBFC, Manos, filing a suit, Manos, taking ex parte orders, and Manos, the orders will just bend to one, Manos, just have, Manos, page 65.
Extended after that.
It has been extended.
It has been
extended. In fact, it was on the list yesterday. I understand it may come again.
There is no effective here. I'm sorry, there is no effective here. Because I'm sorry, because last date, because the matter could not be taken up, they said is extended till the next date of this.
Your Lordship may direct them to file an application for vacation and that can
Because then can I request one thing, Manos, at least Manos will then at least pass a direction, Manos, let them decide in a time fixed manner, Manos.
You've not even filed an application. How will we say that?
I'll
in the event
do that forthwith, Manos.
You file an application and pursue it further.
Can we just impress upon one issue, Manos, the coordinate bench has taken a view that in an appeal, Manos, without admitting the appeal or without restoring the suit, an interim order cannot be.
It has been admitted. Appeal
Without restoring the suit.
Appeal is admitted. Once the appeal is admitted, the High Court is entitled to pass an interim.
If I can show that order,
Unless the first appeal is allowed, the High Court can't pass an order.
There are two things here. One is, could the High Court have passed an order saying that you cannot.
This was an order of restoration. The trial court, after the rejection of the first order 7 rule 11, passed this interim order. And then you file a second order 7 rule 11 and you succeed.
Because the first dismissal was dismissal in default. So there is no res judicata.
So you file a second order 7 rule 11 and you succeed. Against that he's filed an appeal. And the High Court says, all right, restore the
one question I put to myself. Can an interim order be in the nature of prescribing me or prohibiting me from pursuing?
That is something that you'll have to raise in your application there. Under order 39 rule 4.
Favor also for giving me some, at least I file the application forthwith.
We can't say anything like that. Once it's not even filed, what were you doing till date? This order was passed long ago. Having heard the learned counsel for the petitioner and the learned senior counsel appearing for respond number 1, Mr. Ritin Rai.
Please, sir.
You're for.
Yes, I'm for respondent.
And respond number 1. We find that the High Court of Judicature at Allahabad is seized of the first appeal, and what is challenged before us is an interim order passed on 8/4/2025, whereby the High Court directed that the interim order dated 22/7/2024 passed by the trial court should remain operative till the next date of listing. We are informed that this interim order was extended thereafter from time to time, but the petitioner before us, being the defendant in the being the respondent in the said first appeal, is yet to file an application to seeking vacating of the interim order dated 8/4/2025, as it is for the petitioner to pursue that remedy before the High Court. In the first instance, we find no grounds made out to interfere with the interim order at this stage. These special petitions accordingly dismissed, leaving it open to the petitioner to take recourse to such remedy in accordance with law.
Obliged. We were not able to give our appearance in the morning from maybe 10 o'clock. I'm okay.
I'm for the respondent in this matter.
Will I put in a letter for Millards for filing of the rejoinder over here?
You don't have a letter.
Plus a short is short issue is on the aspect of the interest being levied by the arbitrator.
on
You're not going to
default
go into
of
the merits of the matter.
Only that.
Your 37 is dismissed on the ground of
Very
delay.
well, because I understand that. Only as
Why will we go into the merits of the matter? We are only on the
Your Lordship, see para 20, page 20, para 33 for a moment. How the arbitrator justifies the aspect of the interest.
Why would we go into the merits of the matter, counsel, when you are not suited with your 37 appeal on the ground of delay?
Only on.
Do you think that a 37 will be a stepping stone to come before us, irrespective of whether it is from merits? If it is dismissed on the ground of delay? We are only on the issue of delay. So you tell us what you want to on the issue of delay.
Delay is highly because there is a lot of aspect with respect to because in
the
fact
judgment, 34 judgment was on 2nd July 2022.
Come to page
and you filed your your seven appeal on 11/3/2025.
Merits may have their application.
For measure you took how many years? Even Borse brothers stretched to the extreme also will not come to your aid.
Because 145 is the days of delay which has been observed because the whole problem is because there was this time period where the because the paper book could not be because be obtained and
you filed the appeal and not in 25, 23 February.
Yes, and therefore we had
even merits may have the reasoning that had been given by them in their condonation application.
That is page 80.
Page 83.
Page 91 is my application for
83 onwards.
Amended application.
Amended application. 91.
90 it starts and page 92 milos, para 3 milos, I will explain milos. Para 2 onwards milos.
This kind of vague grounds won't do. When will you ever learn? Governmental bodies, they all think that just say that we were using our red tape as usual.
Yes,
so once bureaucratic red tape is pressed into service, we don't need to give further details. No dates, no details. How did the file move? Nothing at all. With that kind of condoned delay petition, obviously the High Court is justified in rejecting it.
Yes, Honours.
Not a single detail. Except for pointing out the holidays for Diwali. That is the only thing you found. Only dates are with regard to Diwali holidays and Christmas holidays. But BSNL has Christmas and Diwali holiday. Phones work even during that time.
These are all very specious bills, but I can't go beyond the record. The only question which I would canvass is that the aspect of interest.
Taking the court for granted, thinking that because you're a state instrumentality, you will be automatically granted extension of time, limitation will be looked.
I could only better my case only on the aspect of interest bills. Other than that, I could not.
We can't go on to the merits at all. No question of.
If your lordship could only see as that as a part which the arbitrator has justified, because they could go into that aspect only, I would beseech your lordship to go there.
Sorry?
The arbitrator, how he has justified the
not on merits, we can't look into the merits, it is not done.
Even if merits, if I may, merits, may I?
When I said, whoops.
Used to take this out.
The judge, in fact, in spite of saying that there is no reason to condone the delay, looked into the merits also.
Because that's one part. Therefore, I thought, would your lordship consider only one aspect of the arbitrator's finding on the aspect of interest? That's the only short issue which I would like to can.
Once the learned judge ends with saying that the delay is not condoned, the 37 stands closed on that ground. Once the 37 is rejected on that ground, your SLP can't go beyond that.
वो ब्लॉगर नहीं पीजी के पास है बड़ा प्यारा चल आगे खाते हैं
Having heard the learned counsel for the parties, we find no grounds made out to interfere with the judgment and order dated 11/3/2025 passed by the learned judge of the Bombay High Court, rejecting the petitioner's arbitration appeal under section 37 of the Arbitration and Conciliation Act 1996 on the ground of delay. The convened petition filed by the appellant, by the petitioner, was absolutely bereft of details and therefore warranted rejection at the threshold as rightly decided by the learned judge, especially petitions according to the priest.
Please, Raj.
May please, Vinod.
Yes.
May I hand over a 2-page note which summarizes what I have to say instead of taking your time to going through all the reports. Look, this is a contest between two wives for succession certificate. The petitioner before your lordship was married to Shankar Sharan Singh in 1985, 27/6/1985, and a daughter was born through that marriage in 1986.
Yes.
But that's the first page of my name. The mistake was a daughter was born and not a son. Sadly. Disappointed with the birth of a daughter, Sharan Singh married the respondent here in 1987. She immediately produced a son and an heir. Now, things were fine for the next few years. And then this gentleman, who was a jailer in the outskirts of Patna, he disappeared, simply disappeared, not found for 7 years. And then both the rival wives filed succession certificates. The succession certificate filed by the petitioner was dismissed on the ground that she could not prove the marriage. That on the second wife, she proved her marriage. The mother-in-law filed an affidavit supporting the second wife. No objection. And then we filed these petitions. Lord, before I get on to the technicalities, I would demonstrate my case on merits by just showing 3 documents. Now, there are 3 admissions. The first admission is the mother-in-law's admission, paragraph 6.1, mother-in-law's admission in a partition suit filed by the first wife. The petitioner filed a partition suit. This your lordship would find at page number 86 of the paperwork. Begins at page number 86, E7.
Yes.
Would your lordship turn to page number 88, paragraph 8? I will read the entire paragraph.
Yes.
That it is stated that late Ram Bhajan Singh was the head and karta of his joint family consisting of him and his sons. The said Ram Bhajan Singh died on so-and-so. After his death, Shankar Sharan Singh became head and karta of the joint family consisting of him, his brother defendant 2, mother defendant 2, and sister defendant 3. Plaintiff number 1, who is by nature a crooked lady, began to disturb the peace of the joint family after the death of late Ram Bhajan Singh. She did not like to remain joint and she did not like to live with the defendant at Patna. Plaintiff number 1 pressed her husband Shankar Sharan Singh for partition in the family. Shankar Sharan Singh, to save the prestige of the family and have peace in the family, pressed the defendant for amicable partition of the joint family property. Lord, that is the first admission. If you come further down, the last 3 lines, so the plaintiff and she may live separately and away from the other defendants. Due to the, yes, Lord, and then they say there is a partition. I'll read the rest of the sentence. In the village property, Shankar Sharan Singh and the defendant 1 and 2 took 1/3 equal shares each.
Where are you reading?
Lord, I read to your lordship the last 3 lines
Yes.
of page 89.
Yes.
I continued that sentence which stops at the next page. 1/3 share each.
1/3 share.
So this is the first admission by the mother-in-law in a partition suit filed by the petitioner of the relationship. No. Then I would come to the admission by the second wife herself. That is at page number 80.
80. What is this document, Mr.
This is a criminal complaint filed by the second wife after the disappearance of the husband. Lord, the document is not dated, but the date is found in the impugned order. The date is 21/8/1995. 21/8/1995.
Well,
I would read the complaint. It is submitted that Shankar Saran Singh, son of so and so, presently resident of so and so, is my husband. My husband is working as a clerk in Jail. We have our house so and so. My husband has married twice. First marriage is with Nutan Devi, resident of so and so. My husband has a daughter through his wife. And for there being no child, my husband married me with the consent of Nutan Devi. Lord, child being male, because the others are not recognized as children. Then at 81, middle of the page, there used to be altercation amongst my husband Nutan Devi and her brother. Few days earlier, brother of Nutan Devi has threatened he would disappear him. And she says the first wife is responsible for the disappearance. But then the third, more telling document is at page number 207. That's the registered sale deed. Annexure P 17. 19. Lord, 207. And the relevant page is 208. Yes.
The sale deed.
218 is the beginning of the sale deed. 208.
208.
Yes. I'm sorry, 208.
Yes. Yes.
Your Lordship has the heading at the bottom of the page, 208.
Yes.
Absolute sale deed prepared on this day, 7/9/2021. Then if your Lordship skips to page number 213, there's the reference.
Yes.
It is executed by the second wife. Party number 5, Vibha Kumari Singh, is the second wife. And Vivek Kumar, 6, he is the son of the second, through the second wife.
Right.
The admission is at page number 217. This is the preamble of the sale deed. It's called reference here.
Very good. Mm. 217.
Yes, bottom of the page 217.
Yeah.
So-and-so property has been purchased from Nutan Singh, wife of late Shankar Saran Singh, resident of so-and-so. Next page also. If your Lordship comes to about 8 lines from the bottom of the page, again from Srimati Nutan Singh, wife of so-and-so. Resident of so-and-so, and since they are in peaceful possession and control of the plot, that vendor number 3 and 4 are selling so-and-so land, that the husband of vendor 5, Srimati Vibha Singh, late Sri Shankar Saran Singh, had married twice. First wife is Srimati Nutan Singh and second wife is Vibha Kumari Singh, who is vendor number 5. After the demise of Shankar Saran Singh, vendor number 5, Vibha Kumari Singh, and vendor number 6, Vivek Kumar's son, they have their share in the estate upon which so-and-so are in peaceful possession.
Now this SLT arises out of the dismissal of your appeal, confirming the trial court judgment, rejecting your petition for a succession.
Yes, there were 2 appeals. One is rejecting mine. The second is affirming the second wife's succession.
Yes.
2 appeals.
2 appeals.
And here your Lordship would have the signatures at page 221.
How does the High Court deal with these?
No, the High Court doesn't look into it.
What about the trial court?
No. These documents, no, my lord.
These documents were not there.
Some of these documents, none of the documents were marked before the trial court. Some of the documents were listed before the trial court, not marked as exhibits.
No examination of the witness.
Witness was examined by some. Look, the problem here was she was a very young widow in a rural district in a backward state, completely ostracized by her family. She couldn't get these documents. All these documents were subsequently obtained from RT.
Now, this succession certificate is something that you want for your share in his retirement benefits.
Yes, retirement
benefits,
benefit,
whatever.
and more importantly, my lord, legitimization of my daughter. She becomes a bastard. Those are the two.
Your daughter must be married by now.
She's just married, my lord, last year. Just married last year, my lord. With these legal proceedings, there was some semblance of a legitimacy with which she could be married. My lord, I would go a little.
So what exactly are you seeking now?
My lord, I am seeking, my lord, if I could, I'm asking for the moon. If I can persuade your lordships on these documents to grant the succession certificate, you can under 142. But if your lordship sees these, no, the High Court made an error, my lord. At each point of time, I filed, along with the, Lord, may I just step back? Before the trial court, I had filed an application for additional evidence allowed. Then I filed another application
for the trial court.
Trial court. Lord, when the
nothing marked in it.
Some documents were marked, and all those documents were treated as irrelevant by the trial court. I am not getting into that. Lord, additional documents such as these, your lordship has seen, were sought to be marked.
These three documents were not there before.
No. At that stage, the trial court dismissed my application, saying you have come at a belated stage. I already allowed one application, now a second application at the stage of arguments. I am not taking them on record, dismissed. Then I went on to the High Court on revision. By the time the revision came up for hearing, the suit was decreed in favor of, and mine was dismissed. The High Court said, take your remedy before the appellate court. So under Order 41, Rule 27, along with my appeal, I filed these applications for additional evidence. In fact, I filed 4 applications. Each time I got an RTI document, I filed another application. 2 applications were filed. One application was filed along with the appeal. The second application was filed 1 year later. Third application was filed few years later. Last application was filed about 2022, 2 decades later. All 4 IAs came up at the final hearing. Unfortunately, the High Court took up the last IA, 2022 IA, and said this IA is completely belated, and there were objections raised to the genuineness of those documents. The High Court said the documents don't seem to be genuine. I am disregarding this, and I am dismissing the appeal based on the evidence before the trial court. Unfortunately, my lord, the High Court's attention was not drawn to the first 3 IAs which were filed along with the appeal. So my first submission is, if my lord could, your lordships has powers. So if you can decide, I'll be much obliged. Alternatively, my lord, if your lordship sees these are additional evidence, the other side must be given an opportunity to react, then would your lordship consider allowing those applications? And
what we are asking you is, what are you hoping for ultimately?
Lord, my hope was a succession certificate before you, but that's a long hope. My submission here is
the death come retirement benefits must have been digested by now. So
not so. Some were given to me.
Oh, you were given some benefits.
Some 27,000 alone was given to me.
Out of?
Out of how much?
So I believe I just give it. Each 100 is given.
Okay, just give it. May I? Lord, it should be about 1 lakh-ish, my lord. I'll get the numbers. But what is now being digested is the second wife, having the benefit of the succession certificate, is selling away the lands. And one of the sale deed is the admission which my lord had seen.
How many lands was he possessed?
Not much, my lord. It's a small community with 1 cert, but whatever they have is truly valuable. And there are 2 children, and they have to somehow fend for themselves, and both of them.
Children. Your daughter is
and her son.
Her son.
So Ideally, my lord, the succession certificate.
There's no possibility of trying to settle the matter?
Not between rival wives, my lord. By very nature, one has to succeed. There can't be two succeed.
Even in the sale deed of 2021, she's acknowledging your presence, though.
Yes, yes, she's acknowledged.
Why do you think that she would be so resentful of you?
Those all are disputed question of facts, Your Lordship.
Where you've executed a
So that's what
sale
I'm saying, Your Lordship. That has not yet been corroborated. First, second is we have all.
Produce a certified copy of that.
Your Lordship,
sale deed. Let us see whether you said that or not.
Why for the reason? Just if Your Lordship will allow me.
You executed this
For just a minute, Your Lordship, if may allow. Because then we are examining over a document. Then why, Your Lordship, for the matter? Then we are examining a document which was never ever produced. This matter, 1997, the husband died.
There is no question of denying a sale deed, a registered sale deed executed by you.
Your Lordship, those documents never been part of any.
We are asking you to produce a certified copy of that registered sale deed.
Your Lordship,
Let us see whether you said that this file was the first file or not.
Only premise, Your Lordship. Why I'm just understanding, Your Lordship, just for a minute.
Do you have a certified copy of that?
I have a certified copy. It's completely Indian.
We are not going to be bogged down by technicalities
Not for that reason, Your Lordship.
when you are being honest enough, even in the year 2021, to acknowledge that you had a Southern. Then
Why for the reason, Your Lordship? In 2000.
you can't.
Your Lordship.
Your client, for some reason, seems to be very truthful and honest. So why do you want to take a different stand then?
Not for that reason, Your Lordship.
You are trying to.
I'm just giving a holistic approach, Your Lordship, just citing another.
Where in this will be?
Where is the
Srimati Nutan Singh, Dharam Patni, Pratham Patni, Srimati Nutan Singh. It's all there.
The address of vendor is also.
All in Shuddha Hindi, it's all there. Pratham Patni, that's what you called her. Pratham Patni, Srimati Nutan Singh. Dvitiya Patni, Srimati Vibha Kumar Singh. So you've acknowledged her status, her existence, all settled.
Why
The question is,
Your Lordship, page 107.
should we again send you back to square one or will you settle now?
Your Lordship, page 107. Just for my interest, Your Lordship, 107. High Court categorically recorded.
You already told me we're not going to be bogged down.
With regard to Your Lordship, how the issues been arises, how these admissions been done. Mother-in-law categorically mentioned in her law.
Mother-in-law
that
is
she is the
also
only.
said in that other.
Your Lordship, that's why I'm
document.
saying what is falling from the record of the court, Your Lordship.
That is the court record. It's a written statement.
This one, no objection was.
Call for a certified copy of that written statement from the trial court.
Your Lordship, just.
There is the question of your saying that these documents can't be
To
looked
this effect, Your Lordship, but it was never examined because for that reason that.
Please give this document back. Keep this carefully, Mr. Virabhu.
I'm obliged.
There is no question.
For that reason only.
Are you willing to at least sit across the table and negotiate?
Your Lordship, for that I have to get back. Why? For a reason what I am submitting, Your Lordship.
Whether you like it or not.
All four documents, Your Lordship, rightly or wrongly, it was there. That
Put it to your client.
I'll
Do not
certainly
advise her that
certainly
on
put
these
it.
lines.
I'll certainly.
Your client seems to be a very honest lady. So put it to her.
But I'm duty bound, Your Lordship.
No, you're not duty bound to advise her wrongly.
No,
She is being
not wrong, Your Lordship, because these documents never been
We are telling you straight out that these technicalities are not going to bog us.
We are not insisting at all. I'm just giving
So the question is whether we send you back to another round of litigation with a status quo order, you will not be able to touch any of the property.
That I certainly put to them, Your Lordship.
Therefore, advise her. It is better that you settle so that she is after all a stepdaughter. She's just been married.
To that effect, Your Lordship, I'm just giving a
mother-in-law is still in the. She's gone.
All those documents which were
After 2 admissions, she passed away.
Put it to your client, please.
Certainly, Your Lordship.
Obliged.
We are of the opinion that this is a fit matter for the parties to attempt settlement of the issue through mediation. Then counsel for the respondent seeks some time to get instructions in this regard. List on 8th December. Sorry, 9th December.
Obliged.
Grateful option.
Item number 26.
Yes, Lord. In item 26, Lord, the respondent state is duty of Puducherry. Unfortunately, I think Lord, the state of Tamil Nadu has entered appearance. Lord, I need to take instructions and I'm for duty of Puducherry.
It is Pondicherry. Pondicherry.
Who has entered appearance?
State of Tamil Nadu.
State of Tamil Nadu.
Mr. Sabarish seems to have filed it.
Yes, Mr. Sabarish has.
It has to be.
Well, the confusion starts because the website
The state is not shown by him. The cost title does not show which state is.
Does not matter. Even in the website, on the question of new.
Why is that?
I don't know whether it was originally shown as so full cost.
What do you mean state by station?
By station, Lawpet police station. No, it's the cost title that is there before the High Court, we write the same thing. So, it's page 12, respondent number 2 is the statement.
So you are appearing for the UT of.
I'm appearing for the UT of Puducherry. What happens, Lord, is originally the full addresses of all the respondents used to be there. We used to know which department, which district. Now it is only Union of India, state of so and so, station house officer.
You've already entered appearance or?
Not yet, I'm informed today.
We find from the office report dated 24/11/2025 that Mr. Sabarish Subramanian, the standing counsel for the state of Tamil Nadu, has entered appearance for respondent number 3 in this special leave petition. However, respondent number 3 is the 3 or 2?
2, my lord.
Oh, I see. It's 1, 2, and 3. So there are 2 criminal OPs, so it would be shown as 3 perhaps. It's not shown separately. This one number 2. What did I say last?
We find from number 3.
So, however, we find that it is not the state of Tamil Nadu that is the respondent in this special leave petition, but the Union Territory of Puducherry. Now, Mr.
Arvind S.
Mr. Arvind S. Mr. Arvind S. Then counsel states that he would be entering appearance for the Union Territory of Puducherry and seeks time to file a counter.
Entering appearance and file.
Enter appearance and file a counter.
Could you not only specify it is R3, not R2? R2.
No, but that's why you have not mentioned a respondent number.
Okay. Very good.
Because they have some strange system. If there are 2 appeals, they have a continuation system, so we don't know who goes where.
And then there are at page 12 and 13.
So it's better to just say it's not the state of Tamil Nadu, but the state UT of Puducherry. That's How much time would you require?
Well, at least 4 weeks.
List on 17th February.
Obliged.
My son appearing on behalf of petitioner Millers. In compliance with my lord's order, state has filed this counter Millers. I only just want to show one paragraph Millers. What state has to say?
You have to tell us what the matter is because I've not read this file.
Millers, initially what happened?
What is it? Is that in the counter?
Millers, state has filed a counter Millers. It's currently paragraph 8 of counter Millers. Page 16 Millers.
8.
16 Millers. Paragraph 8 Millers.
Yeah.
Millers, it starts that it is respectively submitted Millers. I'm just skipping this part.
One moment, I'm looking at the wrong counter.
Counter by state Millers.
Status are one only.
Clean Millers.
Page number 16 you said.
16 Millers, paragraph 8 Millers.
Yes.
That it is respectively submitted that on so and so, Honorable High Court has stated that so and so Millers, middle of page para states. On receipt of the aforementioned order of the Honorable Supreme Court, the investigation commenced and pursuant to the same, the raids were carried on so and so, so and so, so and so. But the aforesaid accused could not be arrested and are absconding, and they might flee to other states. On account of circumstances narrated above, warrants of arrest were taken from so and so, so and so. Notes R2 is appearing before my lords. Notes R2 is appearing before Honorable High Court, my lords. His anticipative was dismissed by my lords in 2025, my lords, 2024, my lords. He has filed this suit selling this property, so I have to file an injunction application seeking a stay, my lords. So, my lords, I'm able to find him everywhere, my lords. State is not able to find him anywhere, my lords. He's appearing before my lords, my lords.
He's appearing.
R2 is entered appearance before my
Filed a
lordship.
counter, that is
Please,
in.
Manoj, I'm appearing on behalf of R2 Manoj.
Where is your client, madam?
Manoj, in fact, after the last order, even I have no contact with my client, Manoj. Your lordship had said that the police
hope you
would be
have
at
collected your
liberty.
fees.
Please, Manoj?
I hope you have collected your fees.
Well, it's partly.
Partly, so you can
Yes.
write it off there.
It's a 2020 complaint, my lords. Yes, in 24, my lords were pleased to dismiss his anticipatory as well.
What have you said in your counter, madam?
Manoj, we have accepted that there is a disclosure that the fact with regard to
Obviously,
the
not a fit case for staying the investigation like this.
Yes,
Your
Manoj.
matter is pending before the High Court. That 482 is still pending, is it not?
Yes, Manoj.
It's pending, my lords.
The 482 is still pending.
We will
and in
only
fact,
confirm
Manoj,
the fact that the order of stay shall stand vacated. Let them pursue. That's all. Stay granted. The appellant is the complainant at whose behest FIR number 312 of 2023 was registered on the file of PS Sohana, District SAS Nagar, Punjab, under sections 406 and 420 of the Indian Penal Code 1860. The accused therein with Satinder Pal Singh, respond number 2 herein, filed a petition under section 482 CRPC, seeking quashing of the aforestated FIR. While entertaining the said petition, the learned judge of the High Court while ordering notice of motion on the said petition on 2/9/2024, a learned judge of the High Court directed that further proceedings in the FIR should remain stayed. Agreed by the stay of investigation, the complainant approached this court by order dated 30/9/2024, not 39. No, we permitted the investigation.
1st of August, my lords.
First of. Don't have a copy of that. Order dated 1/8/2025. This court observed that this was not a fit case for the High Court to have stayed further proceedings in the first information report, as the High Court was obviously not informed of the fact that the accused, the bail application, anticipatory bail application filed by the accused had been rejected not only by the High Court but also by this court, as this relevant fact had been suppressed by the accused while approaching the High Court to secure stay of further investigation in the FIR. This court stayed the said order and permitted further investigation to go on in accordance with law. The State of Punjab filed a counter affidavit wherein it is stated that.
My lords, this is an additional affidavit, my lords, counter affidavit.
It's an additional affidavit.
Pursuant to my
It
lords
says
order dated
counter
1/8.
It doesn't say additional, it says counter.
My lords had directed us to file another counter affidavit. My lords, there are two. One is a short reply and another is this.
Filed affidavit dated 24/11/2020, wherein it is stated that pursuant to the order of this court permitting the investigation to go on, attempts were made to ascertain the whereabouts of the accused Satinder Pal Singh, but without success. He is stated to be absconding as on bail. Though respondent number 2, though the accused Satinder Pal Singh, respondent number 2 before us, filed an affidavit Learned counsel appearing for him also informs that she is not in a position to contact him in the light of the aforestated facts. We are of the opinion that the High Court was not justified in granting stay of further proceedings in the FIR, including the investigation therein. The appeal is accordingly allowed, setting aside the order dated 2/9/2024 to the extent that it directed stay of further proceedings in the matter.
Please, minutes. Please, can I give appearance manually, minutes? I'm requesting to.
Yes.
I'm requesting to give appearance manually, minutes.
Milords, I have a similar prayer, Milords, for
Yes.
revised appearance, Milords, in that. Obliged, Milords.
May I mention one matter? Item 48. The petitioner party in person appears. Lordship last time granted him 4 weeks time to file rejoinder. Item 48. It pertains to arbitration proceedings.
What happened?
Your Lordships have stayed the proceedings before the High Court. And we have filed a counter affidavit in the month of August. 8 weeks were already granted.
The matter should be climbing the ladder now that we've.
Lordship may consider he is a party in person, therefore his Lordship can fix at 2 o'clock or something on next date.
Where is he?
He was not allowed to come inside because by the security. He is here only.
Let him make a mention next week in the event it is not within the zone of consideration. We are expecting that it should come up to at least 26, 27.
So last time it was within 30 and now today it is 148. That's
Is that so?
Well, last time
check out. Why would it go down?
Well, the last time it was 1-3 losses. 13. Item number 13.
It was adjourned.
It was adjourned for the rejoinder.
Without saying that the matter shall retain its position.
No.
If that observation is not there, then it goes. If it is adjourned, you must tell us that the matter should be allowed to retain its position. Otherwise, it goes down. Anyhow, next week it should be coming up.
Item number 37, interim protection may be extended.
It must be till the next hearing.
Yes.
If it says next hearing, did we have a hearing today? Did it say next date of hearing or did it say next hearing? We are now saying next hearing. So that there is no ambiguity.
We granted 2 weeks time.
If it says next date of hearing, perhaps there's a possibility of someone entertaining a doubt.
I may be granted
next hearing. Next hearing is mentioned.
2 weeks time to complete the translation process, deposition.
Well, if it reaches in the meanwhile and you ask for an adjournment, then you go to the back of the list. Otherwise, you burn the midnight oil and finish it by the time the matter reaches.
Not just documents. It took some time to procure documents and it's under translation.
You joined the queue. If you don't want to be in the queue, then we'll take you out of the queue. That's
what
Lordship's
decide.
Malords,
Your
item
choice.
46. Malords, item 46. This is a land acquisition matter, and the respondents have proceeded with the.
What do you want, counsel?
Malords, this may be kept at a specific date.
It is in the list. It will climb up. There's no question of being given a specific date, a specific time. Good Mahurat, not happen.
But without say they have proceeded with the process.
Whatever it is, you will have to wait.
Item 31 below. 31 below.
Yes.
Then just that it should not travel down the list.
Should not.
It's
If
an
it does,
if
it does, please let us know.
Yeah.
Matters are not allowed to slide unless there is a justifiable reason for that. Which would only mean fresh matters being added. Otherwise,
that is my request is for RCK adjournment for 2 weeks to file.
Which are the
doesn't matter.
Why?
We want to file a document which was part of.
File it by the next Tuesday. If it's 31, in all probability, it will reach next Tuesday.
They granted 2 weeks time. I will
No.
Item 49 because I want to file counter for the respondent. Is counter
49, perhaps you might not reach by next Tuesday.
If I'm in the meantime, I'll file.
File it. Who's asking you not to file?
Lordship permission may mention item 30, madam. Allow me to file that. I have served copies.
You need to give permission?
Yes, madam.
There's no need for
Lordship
Lordship permission may mention item number 30, Malord. There's an LR application notice as to void that.
But they're not taking it because there's 5 days.
Did we say within a time frame?
Yes, that's ready.
That time frame has expired. That time frame has expired. Then you file it, they'll take it and show it as defective. Not that they deny the acceptance of the counter. We find the office report saying that it's been filed after time, therefore no condone delay application, but it's still put up because the matter is being listed.
Provided
It's
they-
not as if they won't take it.
Provided they take it.
They will take it. You need to use
Lordship,
your influence.
Yes.
Lordship permission, may I mention item number 30, my lords?
Yes, 30, what do you want?
30, my lords, this is a LR application, my lord. The notice has to go in 32, I'm sorry, 32, my lord.
32.
The husband has passed away, my lords.
32, LR application is shown.
Yes, my lord. It's IA number 238023.
Not shown in the list. Abatement is also there.
My lords, abatement is not there, my lord. The LR application, lordships are already directed. On the last occasion, lordships are passed that. My lords, this is within
Only
time.
LR application. No set aside abatement. No
Within the
further
time.
delay.
So the last occasion, lordships are directed that the needful to be done within.
So when did that person die?
Lord, she died very recently, my lord. It's not
Recently.
that.
Then,
Recently, my lord.
who died? Respond number?
The husband died, ma'am. The husband. Respondent number 6.
6.
Yes, ma'am.
The application, issue notice to the proposed legal representatives of respondent number 6, returnable on third petition.
Well, it's just in addition, ma'am. So,
50, there's a status quo against respondent. Rejoinder and was directed to be filed has not been filed. So request for a short date because it is.
It's there in the list, madam. Why do you anticipate that you need another adjournment again?
Please.
May I mention, Lordship, item number 51, Your Lordship. This is the matter regarding the land acquisition in Manipur, Your Lordship. The land acquisition had already lapsed, and now they are saying that they want to acquire land afresh. They should acquire land afresh and they can complete it within 6 months if they wish. But instead of prolonging this matter, Your Lordship, and the writ petitioners, Your Lordship, they are poor tribal peoples from
Next
the
week it
remote
will be coming up.
areas.
Next week it should be coming.
Yes, Your Lordship, I am seeking some priority in this matter, Your Lordship.
We've been hearing your application time and again. Why was it adjourned last time?
The last time also it got reached because of the positive.
No. Last time once it reached and they said that there's no notification.
Yes, but there was no time to argue, Your Lordship.
Very well. Let's see.